Good afternoon, ladies and gentlemen. We're here to continue the public hearing for Park Central. I wanted to give everyone a little timetable as best I can. We're going to meet right now. We're going to meet all the way to 7 o'clock. At 7 o'clock, we're going to break for an executive session unrelated to the Park Central that we need to discuss, and then we will reopen the Park Central after 7:30 when we reconvene. So that's the plan, and we'll continue on. It's still an open meeting. We have not closed the public hearing, and I just want to let everyone know kind of the timetable, what we're up against this afternoon and into this evening. So before I start, I wanted to remind everyone, just in case there's a fire alarm goes off in the building, there's exits here and in the back, and everyone should go to their closest exit, and we are to meet in the parking lot, in the rear of the parking lot, and that's per order of the fire department. So having said that, I'd like to bring our town council in just for a few words before we get into tonight's meeting.
Thank you, Mr. Chairman. As per the last meeting, I'm going to restate that decorum and orderly conduct in administrative proceeding is the hallmark of having a fair decision on this matter. Mass General Laws, Chapter 30A, Section 20 is in effect. That means that no person shall address the ZBA meeting without the permission of the chair. That's state law. All persons at the request of the chair shall be silent. That's also state law. No person shall disrupt the proceedings of the meeting of the public body, the Zoning Board of Appeals, also state law. If after clear warning from the chairman, a person continues to disrupt the proceedings, the chair could order the person to withdraw from the meeting. That's also state law. If the person does not withdraw, then the chairman has further remedies relative to the local police, which we sincerely hope will never come to that, because that's only happened in Southborough, from my knowledge and speaking with the planning board chairman, maybe twice in all the years that we've been involved, and we've been involved in over 30 years.
Mr. Cipriano,
Excuse me, Mr. Bartolini, let me finish. Can I finish?
I want to correct you on one thing.
No, you're not going to correct me
It has
tonight.
happened on the ZBA
You're
board
not- oh, all right, good.
2.5 years ago.
All
with
right.
the
All
police
right, that's
department.
wonderful. That's irrelevant. The most important point is that those are citizen volunteers. Those are your neighbors. They serve because they respect the town, and they respect you. The respect needs to be mutual to come to a common solution on this. That is so noted in the record. Thank you, Mr. Chairman.
Thank you. Thank you.
He does, and so do we,
Cipriano.
but we don't. But that's
We did have, here, this was part-time job.
Okay, so here's how we're going to proceed from here. To make it run, I think, a little bit more smoothly and a better understanding for the public and the applicant, what we're going to do is we're going to start with the discussion of the order of conditions. And I'm going to let the applicant start with the first one and go right down the list. There are a number of questions that we'll have. Ed Marchand up here, who's our advisor from the state, will have questions. We have Dan from Fuss and O'Neill that will have some additional input on the town's behalf. So we're going to go one by one, and we're going to go through it. At the end, now each one of these conditions is a number 6, number 7, number 12. At the end, when we're done with the last one, if anyone from the public would like to comment about any specific order of condition, or if they want to add an order of condition or modify an order of condition, this is when they would have a chance to speak. So I just want to let everyone know, everyone's going to have, anyone that wants to speak is going to have a chance to, but it needs to be framed where the question is related specifically to an order of condition that was brought forth, or one that they're contemplating maybe adding and want us to consider. So I think it's I'm trying to make it as transparent as I can. As far as any town board, and I know we have a number of boards represented here this afternoon, I think to show some respect to the boards, what I'd like to do with the boards is that we're gonna go through, let's say, every 5 or 6 of the orders of condition. We'll review them, we'll move on. Once we get to the 5 or 6, when I think it's the right time, I'll ask if any board has any comments on those 5 or 6 that we just went through. That way, they would have a chance to you know, voice their concerns or comments, and wouldn't have to wait all the way to the end, because we're very, we're very respectful to the other boards in town, and we want to make sure that their voice is also heard.
You mean
So-
the town consultants, too?
Yeah,
right?
of course, the
And-
town
and-
consultants,
and Dan.
absolutely. So we've already discussed that Dan and Ed will be piping in from time to time. So that's this afternoon's ground rules. I hope that everyone's respectful of the process. We're going to try to do the best we can, and we started this meeting early. I do apologize, but we want to make sure that we have enough time to review all the information that's going to come forth, and I think you know, it'll give us the time to do that. So, okay, so now, Mr. Applicant, would you like to proceed with number 1?
Yes, Mr. Chairman and members of the board, first I'd like to thank Ed Marchant and Attorney Cipriano. This has been a work in progress. The draft decision was presented to the board several weeks ago, and it was certainly a work in progress and is a work in progress through today in terms of not necessarily arriving at a product that everyone agrees to, but arriving at a product that we think that the board should consider, and that's why we're here for tonight. The conditions of approval which are set forth in this draft are not necessarily conditions of approval that the applicant agrees to or agrees with, but they certainly are conditions of approval which we think are appropriate, many of which are required by law. And so I think what we'll do is we'll go through every one, because Mr. Marchant, Attorney Cipriano, I don't know if Joe's had the chance to look through these, okay? And this is what we sort of have a consensus on what an appropriate conditions of approval would be.
Right, excuse me just a second, just so the general public understands, a lot of this stuff is boilerplate language that's on every 40B decision. Is that true, Ed? Correct. Okay, so, you know, most everything here is boilerplate, state regulated and state required, orders of conditions that we have to follow. There's not a lot of wiggle room there. So go ahead, I'm sorry.
No, they're not interrupting me. This is, for the board to basically opine on and include in your decision or not include in your decision. The first section on the conditions of approval are what are known as regulatory conditions. And the regulatory conditions, there are 3 or 4 pages of them, okay? There are 18 separate conditions. Starting on page 8 in the most revised version, and this is the version that Mr. Marchant finally, he just wants to do, no, just the conditions. Just what Mr. Marchant opined on just earlier today, and I'll start with conditions of approval, regulatory condition number 1. The total number of dwelling units that may be constructed on the project site shall be limited to a maximum of 180 rental units as shown on the plan of record. The plans of record are the plans that were submitted dated August 15th, 2016, as this board may modify subject to whatever happens this evening, or subject to a condition that you may impose that requires certain minor modifications in the future. So that would be condition number 1. Condition number 2 is 25% of the dwelling units shall be and shall remain affordable and shall be marketed to eligible households whose annual income may not exceed 80% of AMI, adjusted for household size as determined by the United States Department of Housing and Urban Development, and this is in parentheses, the affordable units, and subject to approval by the project subsidizing agency. Also throughout this decision, subsidizing agency is always referred to as subsidizing agency. At the present moment, it's mass housing. That could change. The affordable units and the remaining units shall be eligible to be included in the town's subsidized housing inventory as maintained by the Department of Housing and Community Development. I don't think we have any problem, the applicant has no problem with that condition either. Condition 3, the applicant shall notify the board and the town administrator when building permits are issued and cooperate with the preparation of request forms to add the units to the SHI, or the subsidized housing inventory. Again, this is a common condition of which we have no problem. 4, the applicant shall notify the board and the town administrator when occupancy permits are issued and cooperate with the preparation of request forms to add the units to the SHI permanently. 5, all units within the project shall remain rental units in perpetuity. For purposes of this decision, perpetuity shall mean for so long as the property does not comply with the applicable zoning or other local requirements without the benefit of this comprehensive permit. Again, that's a standard condition in most comprehensive permits. 6, the affordable units shall be dispersed throughout the project and not segregated from the market rate units as designated by the applicant by agreement with the subsidizing agency. To the extent possible, and subject to the approval of the subsidizing agency, affordable and market rate units shall be allocated on a pro rata basis, including number of bedrooms and floor location. The affordable units shall not be distinguishable from the market rate units in accordance with all applicable regulations and guidelines of DCHD and the subsidizing agency.
All right, excuse me, just hold off 1 second. I just want to make sure that if any board member, I don't think there'd be any reason to comment at this point, but I just wanted to give the opportunity. Any other board that would like to comment on what we just went through? As I just,
We should have the right to do it
Okay.
first.
Okay, and I would also ask that.
oh, excuse me, I'm sorry.
Ed, Mr. Monchon, on number 5, is there anywhere in the decision that there's something put there that if the property was to be pre-sold or anything, that they have to notify the board as if the process presently going through with Madison Place being sold? Does that get? Okay, all right, thank you.
And Mr. Chairman, I'm assuming, and I don't like to assume anything, that if Mr. Marchant isn't making a negative comment, that he concurs with the language that we're reading, so that we don't have to go back over
Right.
it. 7, the applicant shall execute a regulatory agreement that shall be countersigned by the subsidizing agency as required under General Law, Chapter 40B, and submit annual reports to the subsidizing agency in accordance with the regulatory agreement. 8, the applicant shall annually recertify to the subsidizing agency, or less frequently as may be required by the subsidizing agency, the continuing eligibility of any tenant in an affordable unit. Upon request, the applicant shall provide the town with copies of all filings made with the subsidizing agency with respect to the compliance of the project with the project's required affordability levels. 9, if and when the regulatory agreement with the subsidizing agency is terminated, expires, or is otherwise no longer in effect, and is not replaced with another regulatory agreement with another subsidizing agency, and the legal requirements in effect at the time require a replacement regulatory agreement in order to maintain the units in the project on the SHI, or is otherwise required to maintain compliance with Chapter 40B regulations, the applicant shall enter into a permanent restriction or regulatory agreement with the town in a form and substance reasonably acceptable to the board and its council. This is parenthetically referred to as the town regulatory agreement, which shall be recorded with the Worcester District Registry of Deeds against the property and signed by all the necessary parties, including the mortgagees and lien holders of record. The town regulatory agreement shall, so long as the project does not conform to local zoning, 1, require that the project shall remain a rental project, and 2, require that at least 25% of the dwelling units in the project shall be affordable to low and moderate income households, as that term is defined in Mass General Laws, Chapter 40B, Sections 20 through 23. 10. Any such local regulatory agreement shall constitute a restrictive covenant and shall be recorded against the property and shall be enforceable by the town and shall require that the affordable units shall remain affordable rental units in perpetuity, meaning specifically for so long as the project does not conform to the town's zoning bylaws. 11. While the regulatory agreement with the subsidizing agency or one with another subsidizing agency is in effect, the subsidizing agency shall be responsible to monitor compliance with affordability requirements pursuant thereto. However, the town may request and shall be provided by the applicant with all compliance and monitoring reports that are provided to the subsidizing agency. 13. Paragraphs 9 to 12 above, which I just read, shall not be used or construed.
You skipped 12.
Did I? I'm sorry. When the local regulatory agreement, if any, is executed and takes effect, the affordability requirements shall be enforceable by the town or its designee to the full extent allowed by Mass General Law, Chapter 40B, Sections 20 through 23. 13. Paragraphs 9 to 12 above shall not be used or construed or otherwise exercised in conflict with the holdings of Board of Appeals of Amesbury versus the Housing Appeals Committee, 457 Mass 748, 2010, which is a case by the Supreme Judicial Court, or any other relevant decisional law or amendment to Mass General Law, Chapter 40B, Sections 20 to 23, nor shall the foregoing be deemed to limit the town's authority to enforce the provisions of this comprehensive permit in accordance with the legal exercise of its zoning enforcement powers. At such time, if any, as the town becomes responsible for monitoring the affordability requirements for the project, the applicant shall provide the town with a reasonable monitoring fee. Said monitoring fee shall be reasonably consistent with the monitoring fees required by the subsidizing agency. 14. To the extent allowed under General Law, Chapter 40B, and the regulations promulgated thereunder, and other applicable laws with respect to at least 70% of the affordable units, the applicant shall provide local preference categories as requested by the town during the initial lease-up to the greatest extent allowable by the subsidizing agency. The foregoing local preference shall be implemented pursuant to procedures approved by the subsidizing agency. If approved by the subsidizing agency, this preference shall be implemented by the applicant, and the applicant shall maintain records of its marketing efforts, which records shall be open to review by the town for compliance with the local preference set forth herein. The board acknowledges that it will be required to provide evidence satisfactory to the subsidizing agency of the need for the foregoing local preference and to obtain approval of the categories of persons qualifying for the same. And in no event shall the applicant be in violation of the terms of this decision to the extent the subsidizing agency disapproves the local preference requirement or any aspect thereof. If the board or its designee does not provide proof of approval by the subsidizing agency within 60 days of a written request by the applicant, its lottery agent, the subsidizing agency, or DHCD, then this condition shall be void. The applicant shall provide reasonable assistance in a timely manner to the town to prepare any documentation required for approval by the subsidizing agency of the local preference categories. If approval of such local preference by the subsidizing agency is not obtained prior to the time the applicant is prepared to market the affordable units, the applicant may offer the affordable units for rental to all eligible parties in accordance with the requirements of the regulatory agreement and the subsidizing agency. 15, the applicant shall develop a marketing plan for the affordable units for review and approval of the subsidizing agency. Said plan to conform to any and all affirmative action requirements or other requirements as imposed by federal or state regulation, and shall conform with the local preference requirement set forth above to the extent applicable. 16, the applicant shall annually provide the board or its designee with copies of any and all material compliance documentation provided by the applicant to the subsidizing agency or its designated auditor, or of the applicant's costs and revenues for informational purposes upon request of the town. 17, the town, by and through the board or its designee, shall have continuing jurisdiction over the project to ensure compliance with the terms and conditions of this decision, but only to the extent of the board's authority pursuant to and accordance with condition A13 above. 18, prior to receiving any building permit, the applicant shall obtain final approval from the subsidizing agency pursuant to 760 CMR 56.04, paren 7, and shall provide evidence of such final approval to the building commissioner and the board. So those are all of the regulatory,
Okay, all right. Before, does anyone on the board have any questions with what we've talked about so far?
I guess it's minor on 14. So you're saying 70%, that's 70% of the 25% that's affordable? And that, I guess, goes to local meaning Southborough?
The Department of Housing, for the record, Ed Marchand, Chapter 40B, advisor to the board.
Wait.
Oh, no, a little lower, there you go.
For the record, Ed Marchand.
No. There you go.
There we go.
Now you-
For the record, Ed Marchand, still Chapter 40B advisor to the board. The Department of Housing and Community Development establishes allowable categories for preferences. Those preferences include Southborough residents, persons who work for businesses in Southborough, persons who work for the town, or a school district to which Southborough residents send their children. Those are the primary references. They also, one of the preference categories could be households who have children in Southborough's school system. The town itself will select the preferences which it prefers and notify the applicant. The town also has to make the case that those preferences can be recognized and still be consistent with the affirmative fair housing marketing plan. So the ball is in your court. The applicants are always agree to comply with that as long as it doesn't delay the rent-up of the affordable units.
Okay, thank you.
I also, if I could, wanted to make sure the board is aware of the term final approval in condition number 18. And I believe I've explained this to the board before. There are 4 basic steps in the 40B process. The first, of course, is the project eligibility letter, then the comprehensive permit, and then final approval. And at the final approval stage, the subsidizing agency makes an additional review of the comprehensive permit itself and any changes that have occurred to the project, and also reviews a written financial commitment for building the project. Those are the basic elements. They will also, at that phase, review the lottery plan and the affirmative fair housing marketing plan. An approved fair housing marketing plan is critical because that's one of the conditions for including these units on the town's subsidized housing inventory.
Thank you. Okay, before we go into the detailed part of this analysis, of this review of the conditions that's specific to this site, does any other board have any questions or comments, or Fussin O'Neill, or anyone have anything on the boilerplate stuff that we just reviewed? Okay, just want to make sure. All right, so let's talk about, Angela, why don't we talk about
The general
the
conditions?
general conditions specific for the site?
And I note that Mr. Marchant may have some comments on some of these as we go along. The first general condition is that the board hereby grants waivers as set forth in Exhibit 4 attached here too. Exhibit 4, for the information of the board who isn't intimately familiar with this decision and the public, were the minutes of the meeting held by this board in which waivers were granted. Okay? I'm going to read the rest of this condition. I have some issues with it, but we'll read it first, and then we can have a discussion, and I believe that Mr. Marchant may have some issues with it. The board hereby grants all of the waivers set forth in Exhibit 4 attached here too. In addition, to the extent any other waivers of the requirements of local laws or other local rules and regulations are required to construct the project as shown on the plans of record, those waivers are also hereby granted. Except for the relief granted by the board relative to specific waivers granted and as set forth in the preceding sentence, the applicant shall comply with all provisions of the general bylaws, zoning bylaws, and all the rules and regulations applicable thereto, including but not limited to the Conservation Commission, the Planning Board, and Board of Health generally applicable to a project. Any fees that are to be waived are as specifically set forth in Exhibit 4, with all other fees as may be generally applicable to such projects in the town being applicable to the project. If I just may make an initial comment, this decision defines the word project as the 40B affordable housing development and not the use variance, okay? This comprehensive permit applies only to that project and the connector road that connects to it, and then, of course, the infrastructure, drainage, and stormwater that does affect everything else, but it doesn't apply to what has been referred to as the 40A project because it was approved by this board unanimously under as a use variance. When you voted in your waivers, okay, you made one of the conditions or one of the waivers subject to further comment and review by, I believe, the Conservation Commission and the Planning Board. The Conservation Commission retains jurisdiction under the Wetlands Protection Act for this project, for this entire development, okay? So we don't need a waiver of the Wetlands Protection Act. This board did waive the local bylaw for this project, the local wetlands bylaw, and the Conservation Commission has had time to comment on that, I believe. That will, I can't speak for the Conservation Commission, but that will not be part of the order of conditions under the Wetlands Protection Act. So we would like to make clear that in your decision tonight, and then we would be asking the board to specifically confirm that you are waiving the local wetland bylaw regulation. I don't know if it's clear enough the way that we have it. The second issue is that one of the way that you voted in the waiver regarding the planning board was that the planning board was the site plan approval as set forth in the use variance is under the jurisdiction of the planning board. We don't disagree with that, but we do disagree that the planning board has any jurisdiction over this aspect of the project. The variance was very clear, and we are still before the planning board, okay, on the townhouse component. So with that said, those are my concerns with the waivers, and I want to make clear that the waivers that you are granting tonight are inclusive of a waiver of the wetland regulation, and do not condition anything on the planning board approval of the site plan for the 40B project. And I don't know, Ed, if you had some comments on this.
Do you have some comments?
Normally, this language would be common to comprehensive permits, because the intent of a comprehensive permit is to grant a permit that requires no additional approvals. That's why it's called a comprehensive permit. You're acting on behalf of all local boards. However, when I reviewed the minutes from that meeting, which are referenced as Exhibit 4, some of these waivers were conditional, and that was the concern. So I wanted you to be aware of that, because there's an inconsistency between this document and this language. This language says, whatever is necessary to build the project as shown on the plans of record that you have approved, the so-called August 15th plans, is okay. So the language, if you look at the minutes, particularly numbers 8, 9, and 10, say, for example, on lower impact development, known as LID development, subject to reconsideration of special conditions based on planning board comments. That would be inconsistent with the nature of a comprehensive permit. Water resource protection, number 9, subject to reconsideration by the Conservation Commission comment. Number 10, subject to reconsideration on Conservation Commission requirements. And I believe there was also one here that included the planning board. Number 7, although that references the townhouse development. As the applicant's attorney stated, this comprehensive permit has been drafted to focus on the Chapter 40B project and not the 40A project. So what the attorney is asking is that you grant a waiver to the entire local wetlands bylaw. You have the authority to do that. You do not have the authority to grant waivers to the State Wetlands Protection Act. The applicant must comply with that. I think that's the sum of my comments.
Does any board members have any questions about that? No, I mean, I think if Mr. Pasamato, if you have any comments from the Conservation?
Is this on?
Yes,
Okay.
it is.
Mark Pasamato, Chair, Conservation Commission, Southborough. So, for the record here, I just want to make sure everybody's aware that we received a set of revised plans last week. Those plans represent the, supposedly we haven't, our consultants are still reviewing them at this point. We're still waiting for some supplemental information to come in that supports some items in those plans. Those plans represent a couple of working meetings that we held with the applicant, their engineers, their consultants, Fuss & O'Neill, our consultant, and our also environmental consultant, Lucas Engineering. As a result of that, we're right in the middle of going through the project, the changes to those plans, and there's substantial changes to understand how the design is in concurrence with the Wetlands Protection Act, which is, Mr. Marchand has said, that is something that you cannot waive and the applicant must meet. We're also going through that and looking at its concurrence with the Wetlands Town Bylaw, which you have waived, and have also asked us for feedback for possible reconsideration should there be substantial impacts as a result of the project and impacts to that bylaw and the stormwater management bylaw, town bylaw as well. So we're just in the middle of that. We have a special meeting scheduled on the 31st of this month with the applicant that we hope to be able to make some progress on the issues that were identified and the plan changes that were made. I'm not sure that we'll be able to get through everything at that point in time. It depends on our consultants being able to get through the issues, the receipt of the supplemental materials, and so forth.
Okay, thank you.
Thank you.
I mean, I think it's important to note that the waivers, and this has been said already a couple times, but the waivers that we did grant with regards to the local wetlands bylaw do not override any type of state or federal regulation. So those are, any type of approval that we grant tonight on this would be subject to final review from conservation, and also making sure that they feel comfortable that the project will not violate the state or the Federal Wetlands Act. Any other comments about that? Now, with regards to the planning board, I think it was back in January or February, correct me if I'm wrong, I think it was somewhere around January. They presented some comments to us after their review of the 40B project, and some of which we felt as though there would be, it was something that we wanted to incorporate in an order of conditions. So we have taken some of their comments, and we feel as though that it's definitely applicable for this project. So I think that it's difficult for us to comment on the 40A aspect. We're not here to vote on that. So I think we've got that covered, and I hope that we've explained to you, Angelo, that we understand what waivers we did grant with regards to both those.
I just want to, it's important that the decision be clear, okay? And paragraph 1 of the general conditions is not totally clear, because Exhibit 4 still references, as Ed and I have pointed out, that there are certain reconsiderations that the planning board may have. Elsewhere in this decision, this entire comprehensive permit is subject to an order of conditions, a final order of conditions from the Conservation Commission. And if, as the chairman of the Conservation Commission noted, that order of conditions, okay, requires changes to the plan that we're seeking approval of tonight, well, unfortunately, we find ourselves back before you. Okay, that's the reality of it. But that's the reality that we're willing to accept. I mean, that's what the law is, and so we.
And that's normal with any 40B projects. I believe I mentioned this the other night. Developers can decide whether to process a notice of intent before the Conservation Commission simultaneously with a 40B review, or do that after the comprehensive permit is granted, or a little of each. So boards always include a condition if the order of conditions hasn't been issued, or even if it has, that the project must comply with the order of conditions issued by the Conservation Commission. It's as simple as that.
Anyone have any other comments with regards to this first? Okay, all right, so let's move on. Oh, excuse me, I'm sorry. Planning board would like to chime in.
Phil Jenks, Planning Board. Your general conditions be number 1. About halfway through, you say applicant shall comply with all provisions of the general bylaws, zoning bylaws, and all the rules and regulations applicable thereto, including but not limited to the Conservation Commission, Planning Board, and Board of Health, would it not be appropriate to add to that the zoning board's own regulations under 40B, for the 40Bs? Or have you waived your regulations?
It does specify zoning bylaws. I'm assuming that it,
Would that be redundant, or?
I don't think that's under the zoning bylaws. I think the zoning board, you're familiar with those, I
Mr.
believe.
Bonchon, will
Lee?
you explain that to him, please?
I don't know that, I'm going to defer to town council, but the question is whether those rules are included in general bylaws.
right. Well, should we add them specifically, town council, if you want to?
Sam here, Sam, okay.
I would have thought, again, you don't try to list everything. It would be an unwieldy list. So you try to make this general, and very often it's all local rules and requirements.
Thank you.
Okay.
Yes.
The rules and regulations are promulgated under the bylaw, but they are not part of the bylaw, and respectfully, we would submit that they not be waived.
Well, I don't think we're looking to waive them. I think the question was, should that language be included in that provision, no? Or, am I understanding that
Right.
correctly?
Yeah, we're not looking to waive that. We just wanted, I think Mr. Jenks had suggested maybe we include the
Additional
language that our rules and conditions will be in.
They're in effect and
Effect.
enforceable invertedly, that's what I'm saying is that it needs to be added.
That,
Okay, so
Relative
that
to your
language
rules.
does need to be added?
Yes.
Okay,
that, does the app,
okay, that's,
does it?
yeah, so
are
we
they
can,
following that?
yeah, do you understand, Angela, what we're talking about?
Yeah, well, yeah, basically you're saying that that you want added to that sentence, the applicant shall comply with all provisions of the general bylaws, the zoning bylaws, the rules and regulations of the zoning board of appeal promulgate, I don't know the technical name of that document, but
Right,
pertaining to
with
comprehensive
regards with regards to this project, I guess.
Well, I think
Yeah.
just adding the zoning board to that list of,
No, you need, what they're referring to is the rules and regulations of this board for the 40B projects. Correct. And
Right.
I just don't know the exact name of it, but before we're done editing,
Okay.
we'll get the exact name
Maybe
of
Joe
that
can help
document.
out with that. All right, thank you, Mr. Jenks, for pointing that out.
And and then moving on, as I said earlier, the only other edit that we would like to see in this is that it's clear that these waivers are not conditional upon further comment by the planning board for the 40B project.
I agreed.
Okay. 2, the project shall be constructed in substantial conformance with the following plans of record entitled Comprehensive Permit Plans pursuant to Notice of Decision on a Use Variance, Town of Southborough Board of Appeals for Park Central in Southborough, Massachusetts, parens, Worcester County, date November 4th, 2015, revised January 6, 2016, January 26, 2016, April 6, 2016, and revised August 15th, 2016. Those are the plans that were submitted to to this board and to the various other boards within the last couple of weeks. And those are the plans which are what we're referring to as the plans of record. And those are the plans that the comprehensive permit pertains to.
All right, just Karen, I just want you to confirm that we have all that stuff on file that he's referring to, all these dates. I just want to make sure that we have in your collection of data, in your,
And the critical one, of course, is the most recent one.
right,
It will include all those other revision dates on it.
okay.
August 15th.
Yeah, August 15th. Right, it's critical that we just make sure that these, it does include everything and.
it appears it does from this.
Yeah.
Yeah,
Yeah.
it appears it
I just
appears
want-
it
right,
does.
Right, okay.
Those dates are
I just wanted to
accurate.
make sure the
They're
previous
on
ones-
there, yes.
Okay,
Yeah.
that's all, I just wanted to go
That's
on
the
record.
official name, that's the official title of the plan. The next condition is one that I think there's a consensus, and this goes along with what we discussed earlier. In an initial draft, it referred to the project is subject to final site plan approval pursuant to section 174-10-2 of the zoning bylaws. That's not accurate. This project isn't subject to final site plan approval. The variance or the townhome portion of the development is. As I said earlier, for purposes of this comprehensive permit decision, the word project is just the 40B project. So we don't feel that this particular condition is appropriate or is even accurate to be included in this comprehensive permit decision.
I would agree with that.
Okay, so we could take
You
the
could
word.
delete,
Delete
word
it.
delete
plot-
it in its entirety.
The whole paragraph?
Yes.
Yes.
So strike
That
number
was on
3.
one of the original drafts I
Okay.
had seen. Because I was not involved with the 40A project, I didn't feel comfortable deleting it from the draft.
Okay.
Tell Joe so he takes and does it on
Yeah,
record.
Joe, you're on board with that?
There is a sentence that is, as you can see below that paragraph 3, that I think should be, and maybe Ed could agree, should be part of paragraph 2. It says that any deviation from the plans of record may require a modification of decision by the board as set forth in 760 CMR 56.05 parens 11. I have no problem with that remaining in there, because that's the law. I mean, unless.
Right, and I would just make that 3.
Make that 3 instead? Okay.
Right. That works out well with the numbering.
The regulation controls.
And again, that references the standard requirements for any changes. To remind you, there are always changes after the comprehensive permit is approved. Because as I said, as developers prepare and submit the final approval application, and as they do more detailed work, because 40Bs are based upon preliminary information, there will be changes. You've been through this drill before. The developer is responsible for notifying you of a change. You are then responsible for determining whether it is a insubstantial or substantial change. If it's insubstantial, you can approve it. If it's a substantial change and there are guidelines that define or suggest the difference between an insubstantial and substantial change, you would need to, one, make that determination within 20 days, and within 30 days, schedule a public hearing, and then make a decision.
Should there be language in that says substantial deviation, or you just leave it
No.
as deviation? And we determine if it was substantial or
Because
substantial?
the language, if you looked at 760 CMR 5605-11, it would explain that.
Okay.
Because you don't want to get into substantial, insubstantial in this language.
Okay.
You're protected, any change, technically, they're required to come back to you.
Gotcha.
Okay, so number 4.
4, the applicant has proposed, and I agree we have, and the board hereby requires that all infrastructure shown on the plans of record as serving the project, with the exception of the improvements to the intersection of the Connector Road to Flag Road and of Flag Road to Turnpike Road, including but not limited to the following aspects of the development, shall be and shall remain forever private, and that the town shall not have now or ever any legal or financial responsibility for operation or maintenance of the same. A, all roadways, parking areas, and emergency access, including sweeping and line markings. B, storm water management facility. C, snow plowing and ice control. D, landscaping. E, trash and recycling removal. F, street lighting. G, septic wastewater treatment and drain utilities. All, parens, all as located on as-built plans. H, electric car charges, parens, to the extent provided. I, water utility lines for both domestic and fire protection uses. In this regard, the Connector Road shall never be dedicated to or accepted by the town of Southborough as a public way. Five, in accordance with 760 CMR 5605, parens 12, parens C, this comprehensive permit shall expire 3 years from the date that the permit becomes final, unless I, prior to that time, substantial use of the comprehensive permit has commenced, or double I, the time period is otherwise told in accordance with law. The applicant may timely apply to the board for extensions to the comprehensive permit as permitted by law. This 3-year time period shall be told for any time required to pursue or wait the determination of any appeal or any other state or federal permit or approval required for the project. For purposes of this decision, substantial use shall mean the commencement of actual site construction with no periods of interruption greater than 120 continuous days, except to the extent caused by matters outside of the applicant's reasonable control. This decision is deemed to have become final upon the expiration of the appeal period, with no appeal having been filed, or upon the final judicial decision following the filing of any appeal, whichever is later.
Should we add the word local as well as state and federal permit, any other local permits we might need?
No, because that's not the reg. May I just have a moment, Mr. Chairman?
It's the regular agent.
There's no other steel. Everything's very, this is the comprehensive permit.
It says every 3 year doesn't total for that we've got in our state. The 3 year period doesn't start till any other state or federal permits are in. Or if there's a local permit that we don't have. Okay.
6, the applicant shall prohibit trailers, boats, trucks, parens, excluding personal SUVs and personal pickup trucks, and unregistered vehicles from being stored or parked outside on an overnight basis within the project's parking area or on the portion of the connector road within the project site. 7, the provisions of this comprehensive permit decision and conditions shall be binding upon the successors and assigns of the applicant, and the obligation shall run with the land. In the event that the applicant sells, transfers, or assigns any of its interest in the affordable housing apartments, this comprehensive permit shall be binding upon and benefit the purchaser, transferee, or assignee, and any successor purchasers, transferees, or assignees. Prior to substantial completion of construction, this decision may be transferred pursuant to the provisions of 760 CMR 56.05, parens 12, parens B, upon approval of the subsidizing agency and after submission of notice to the board. After substantial completion, this decision shall be deemed to run with the land pursuant to 760 CMR 56.05, parens 12, parens B. 8, the project site infrastructure shown on the overall project component plan and associated with a building within the project shall be substantially completed prior to the issuance of a certificate of occupancy for that building. 9, the applicant shall copy the board on all material correspondence between the applicant and any federal, state, or town official, board, or commission that concerns the design and/or conditions set forth in this decision. 10, if at any time after the date of this decision, prior to the commencement of construction, the subsidizing agency rescinds or revokes its project eligibility determination for the project, this comprehensive permit shall be deemed null and void and have no further effect unless, within a reasonable time period after such rescission or revocation, the applicant procures a substitute project eligibility determination from a replacement subsidizing agency. 11, this decision is deemed to have become final upon the expiration of the appeal period with no appeal having been filed, or upon the final decision following the filing of an appeal, whichever is later. 12, the project shall conform to all applicable state and federal laws, codes, and regulations, including but not limited to DEP stormwater management regulations, except where more stringent standards are imposed herein for construction of the drainage infrastructure. 13. Unless, Ed, did you have a comment on that?
No, the only comment is, number 11 is redundant.
Of
We
somewhere
had
else,
that
yes.
in number 5, so I would delete, recommend that 11 be deleted.
And I'm gonna continue with the numbers as they exist, even though we now know we're gonna be renumbering. Okay. 13, all utilities located on the project site shall be installed underground, subject to support by the town in applications to Mass DOT for any utilities that must be located within the state right-of-way. Further, the requirement for any such underground utilities, if located within the state right-of-way, shall be subject to review and approval by Mass DOT. If Mass DOT does not allow such underground utilities within the state right-of-way, then those utilities may remain above ground. 14, all buildings and structures shall be constructed substantially as represented in the application, as revised, and on the plans of record. 15, the project shall be served by municipal water at the applicant's sole expense in accordance with the Southborough Department of Public Works, DPW, and Engineering Department requirements. All facilities shall be installed as shown on the plans of record. 16, the project shall be subject to the review and approval of the DPW, with the applicant to return to the board for waivers as desired and necessary. And, Mr. Chairman, I know Ed may have a comment on this, but this is a condition which the applicant does not agree with, because there are no further approvals required by the DPW that do not pertain to water, and there is a special condition in here regarding the water pressure issue, which we do agree with.
And I wasn't clear on this one, and I don't think it's necessary.
I'm not sure what they're referring to, if it's even
It
referring
was
to.
unclear to me.
Yeah, if they're even referring to water.
No, they're not, I don't know what they were, this was a condition that was cloned off of another comprehensive permit for another project.
Right.
And I don't know the relevancy of it. But for this project, okay, there is no other DPW requirements that I'm aware of that we would need to have enforced or waived.
Is anyone from the DPW here? Is Karen here? I don't think so. Just to get some clarification, if, okay. All right, I believe you're right. Some of this stuff was pulled from Madison Place.
Most of this decision.
And I think that's where
are
this
all
one,
through Madison
this one
Place
came from.
on the majority of all
The,
these
the
conditions.
regulatory, I certainly updated the regulatory section, because some of those rules have changed, and requirements have changed since Madison. But I think this was left from that.
Right, so we're gonna-
I do not think it's necessary.
So,
Remove it.
you have a problem with removing it?
I don't have a
Okay, all
problem
right.
with
I think we're gonna remove that, Joe.
Number 17. Water service booster pump for the project shall be designed and installed to the reasonable satisfaction of the Director of Public Works. 18.
What I'd like to see in here maybe is just to see who's paying for it. I know it's assumed, but the booster pump for the project, excuse me? Go ahead.
So what I agreed with Karen was that we would hire the town's consultant to design the booster pump.
Okay,
But everything, the design and installation
Everything
is
is
the
on us,
responsibility of
exactly,
the
right.
applicant.
that's all. I just wanted to have, I'd like to have some language in there that says that,
She agreed to that. We have a letter on that.
Right.
Karen, did we not get a letter today from?
What I can add, Mr. Chairman, is water service booster pump for the project shall be designed and installed at the applicant's exclusive expense to the reasonable satisfaction of the
thank you.
Director of Public Works.
Exactly, perfect. Yes, Mr. Cipriano.
Mr. Chairman, respectfully, I would request that the word reasonably, the reasonable satisfaction of DPW, that the word reasonably be removed, and it just be their satisfaction. That's a discretionary standard, but
I understand.
that lessens the standard and makes it subject to dispute.
Any comments from the board on that? I would have no objection to that.
We're okay with that.
Okay, all right, so why don't we get rid of, okay,
We will omit reasonably.
thank you.
I'm going to just make one more item.
Yep.
Shall be designed, installed, and maintained.
Maintained.
'18, and I know that Ed had a comment on this also, but I'll read it. All lighting for the project, as detailed on the plans of record, shall be maintained in such a way that lights shall be shielded and directed so as to avoid light trespass exceeding .05 foot candles at the property line or unshielded point sources of light visible from town public ways or adjacent properties outside of the overall site unless otherwise noted on the plans of record.
Attorney Catanzaro, I think it was just a misreading. You said .05.
0.5.
0.5.
0.5 is okay, I assume.
I believe that's what the lighting plan provides for.
So this might be redundant, but it's not it's okay. It's belts and suspenders. You could keep this in if you want.
Okay.
19, the following,
Oh, hang on. Unshielded point source of light, what would that be? But I don't want to get into if someone's got a light on their kitchen, they can see it from Blackthorn Road, that's a problem. That would be an unshielded light. I mean, can we get rid of that last sentence, Ed?
Let me read it.
Well, I'm assuming it's light from that you're controlling, not tenants, or,
I don't know. It's not, I just don't want to get into people calling the building inspector after because they can see lights coming from the building.
His common area lights, not.
I mean, if we're talking.
I
parking
think
lot
it's
lights-
referring to lights in the parking lots, roadways, and if applicable, on buildings.
So common area.
I'm
Yeah, but
okay.
it would
You-
only be
You
the
don't have
40
responsibility for, if someone has a bright light in their unit,
It would only be in the
difficult.
40B buildings.
Right.
yes, Dan.
Yeah, that deals with exterior lighting, so
Okay.
it wouldn't include any interior building lighting.
so
But the
can
un-
we
the
just say
unshielded-
all
Exterior
exterior?
lighting.
Exterior lighting.
Exterior lighting.
But the unshielded is an important consideration, so I would keep that in.
Yep,
So all exterior lighting for the project.
okay.
Yep.
Thank you.
19, the following plans have been reviewed and approved by the board. Lighting plan, landscaping plan, plan showing play areas, snow removal plan. Minor revisions to such plans shall not require a new public hearing or amendment to this decision, and approval shall not be unreasonably withheld. 20, all utility work and any other road work performed by the applicant in connection with the project within any public right-of-way shall be performed and conducted in conformance with the regulations of the town and Mass DOT, if applicable, including requirements for street opening permits and trench permits. 21, contractors shall be duly licensed as required by the town of Southborough. All such work shall be performed in accordance with current engineering and construction standards. 22, all internal sidewalks and street trees within the project and along the portion of the connector road with the project site shall be installed before issuance of the first occupancy permit for a residential unit within the project unless a suitable performance guarantee is in place. 23, the applicant shall provide 24/7 monitoring of the project during and after construction, either by on-site management or an off-site management entity that is available by phone 24/7. In the event the applicant engages a management company, the applicant shall post the name and telephone number of the management company on the front door of the project's leasing office in a prominent place. The phone number of the construction supervisor shall be provided to the town manager and town police. 24, fire hydrants shall be located consistent with the location shown on the plans of record and as required by the fire chief. 25, the applicant shall submit in its building permit application final fire alarm sprinkler plans to the fire chief solely to ensure that the same comply with NFPA 13 standards and any other applicable state requirement. '26, the applicant shall equip each unit with water-saving plumbing fixtures in every bathroom, kitchen, and laundry area within the affordable housing apartment buildings, and all underground water pipes shall have watertight joints.
Could you just simply substitute rental for affordable? That would make it more consistent with everything else.
Yep. Prior to the commencement of construction, 27, prior to the commencement of construction, the applicant shall obtain a National Pollutant Discharge Elimination System general permit, or an NPDES, from the United States Environmental Protection Agency as and to the extent required for construction of the project. For the purposes of this comprehensive permit, commencement of construction shall mean grubbing and clearing. 28, prior to issuance of any building permit for the project, the applicant shall conduct or submit a report, if completed, a hydrant flow test to determine available flow and pressure to fight a fire at the project site, and provide the results of such test to the water superintendent and fire chief. In the event that there is insufficient water pressure or volume for fire protection at the project site, plans shall include on-site improvements such as a fire pump or off-site improvements to the municipal water distribution system as required to maintain a residual pressure of 20 psi in the municipal water distribution system. The procedure for flushing, disinfecting, and pressure testing of the water mains serving the project shall be approved by the town's water superintendent.
And wait, and who's gonna pay for that?
Well, this isn't worded right.
Yeah.
So we don't need to do any off-site mitigation. We can mitigate on-site with the booster pump to handle our
Okay.
pressure.
All right, so it's just your pressure on
Correct,
site.
right. That part where it says, off-site improvements, that should come out.
So,
I think this limits it, as I read this, but I understand Mr. DePietri's comment. To fight a fire at the project site and provide the results of said, in the event there's insufficient water pressure or volume for fire protection at the project site, plan shall include on-site improvements, such as a fire pump. So, the only off-site if you could solve this or resolve this problem on-site with a booster pump, that's fine. If you couldn't do that, I think what this meant, if you had to do off-site improvements, that's why we're talking about it here. We're not talking about doing off-site improvements to service any project other than your own project.
so
Yeah.
I guess, all right, so during the construction process, that pump is gonna be installed. That's gonna be one of the first thing that's gonna be done.
Well, it goes in with the water mains.
So the water main goes in when the road gets cut,
Correct.
and then, so before any building starts going up,
Yes,
the water will be brought in, the pump will be in.
and operational.
Okay, so I guess my question was that if something happens, let's say while they're cutting the road, for instance, one of the construction trucks starts burning, and that pump's not in place, and the town, let's say, has to, make do with the pressure that's there through some of the feeder roads to get to that spot. And I guess if there's any type of maintenance to the system because of it, and it is off-site, I just wanted to make sure that you would pay for it, that it would be included in a catastrophic fire where the water main isn't in, the pumps aren't in yet, that if it falls back to whatever the town has existing to fight that fire, I just want to make sure that there's some type of language in there that the developer will reimburse the town for any expense that they would incur for that.
For fighting the fire.
Yeah, that's all.
Well, this
We
does,
simply say, such as a fire pump and/or off-site improvements?
No, it's-
plan shall include on-site improvements such as a fire pump, okay? And then we could add, or if on-site improvements do not correct the water pressure issue, off-site improvements to the municipal water, okay?
I think that would be satisfactory.
That's fine.
Does Aldo have anything?
Town council, do you have anything?
I believe an engineer does.
Oh, okay, Dan. Sure, go ahead. Feel free to chime in anytime you.
You guys are on a roll. Just a question, for the record, Dan Delaney, with Fussin O'Neill, the town's peer review consultant. Number 19, I was just a little confused about the wording, with the final plans have been reviewed by the board, reviewed and approved. The lighting plan, landscaping plan, plan showing play areas, and snow removal plan. None of those three plans are actual plans in the plan set. So the landscaping and lighting plan are their own plans in the plan set. The plan showing the play area, I believe that's shown as part of the layout plan. I don't know, Danny might know better. I was just trying to check, and same thing with snow removal. They're areas, they're small pieces of information shown on a portion of the plans. I wasn't sure what the intent was there, and
Yeah, I get that. I have some notes,
Right, that was unclear to me, because I haven't been. to
because,
all
I have some notes here referring specifically like to the snow maintenance. Have you designated areas on the property for snow maintenance? Will there be snow removal? That type of thing. I mean, I don't know if,
Well, this may have been a remnant from earlier decisions. We didn't have final lighting plans or landscaping plans. If final lighting, landscaping, recreation area, and snow removal plans have been included in the plans of record, I don't think you need this entire section.
okay.
I think you could delete 19 in its entirety.
I mean, they are part of the full plan set.
Right,
And that's one of the reasons I highlighted in yellow. I wasn't
Okay.
saying-
And Ed, what about the last sentence?
That's already covered, because that references changes in a
And-
comprehensive permit, and we've referenced that.
Okay,
So 19 is
So
gone.
19 could be deleted.
because it's already covered on the,
It's already covered. As
Okay.
long as those plans were part of the plans of record, it's done.
okay.
And then the other question I had, Mr. Chairman, was, I'm not sure if it's in the general conditions we want to put it or in the special conditions, but specifically referencing Fussin O'Neill's review letters as conditions of approval, so that any outstanding items that we've raised to date are included in the decision and have to be addressed.
We were gonna put that at the very end.
okay. They're gonna
That-
add it as
Could
the
you provide us, maybe
I-
soon?
I can give you the dates.
Language that just references that in the letter dates?
Yeah, it's in the last paragraph of the letter I sent today,
Oh, okay.
so you can feel free to steal that from that
So
letter.
we should incorporate that as a condition in the decision.
Yep.
Correct. Correct.
Right, in your additional comments
Correct.
and the recommendations?
Yes.
I think this is just a copy.
Okay.
It's their letter dated August 24th of 2016, and when we get to the end of special conditions, well, we can put that in.
So that we can talk about that in special
Yep.
conditions? Okay. Thank you.
All right, I believe we're up to,
29.
oh, no, there have been, now, in the version that I have, Ed, it appears that you've stricken 27, 28, and 29.
I think I've moved them.
Okay, so those are, so I can now go on to subsection C,
C.
construction conditions.
And just make sure I'm not mistaken, what did your 27 say?
The project's Park Central Drive entry.
Yes, that I've moved to special conditions.
Okay. C, construction conditions. 1, to the extent required under any order of conditions issued for the project, and that would be the order of conditions issued by the Conservation Commission, or a superseding order by the Department of Environmental Protection, erosion control and tree protection measures shall be continuously maintained throughout the course of construction. Adjacent public streets shall be swept as needed to remove sediment and debris, and disturbed areas shall be brought to final finished grade and stabilized permanently against erosion as soon as practicable. 2, the project site infrastructure shown on the plans of record and associated with the building within the project, including all appurtenant site drainage and utility work and installation of a binder course of pavement on driveways and parking areas serving such building, shall be substantially completed prior to the issuance of a certificate of occupancy for that building. Prior to the issuance of the first certificate of occupancy for any residential building within the project, a reasonably satisfactory surety instrument that shall not expire unless and until it is satisfactorily placed or released shall be provided to the town in an amount to be determined by board's consulting civil engineer performing the construction inspection, sufficient to ensure the completion of the top coat of paving and completion of all trench repair work. The surety shall be held in accordance with the town's normal procedures, and any surety release that occurs shall be made only upon the satisfactory completion of the work in question as voted by majority vote of the board after receiving the recommendation of the board's consulting civil engineer. Such surety shall be held by the town treasurer until the applicant provides commercially reasonable evidence of the applicant's substantial completion of the work secured thereby. 3, to the extent that all landscaping for the project shown on the plan of record is not completed prior to the issuance of the first certificate of occupancy, the applicant shall provide to the board a reasonably satisfactory surety instrument that shall not expire unless and until it is satisfactorily replaced or released, and shall be in an amount to be determined by the board in consultation with all relevant town officials and other consultants based on the applicant's reasonable estimate of the cost to complete such landscaping work. Such surety shall be held by the town treasurer until the applicant provides commercially reasonable evidence of the applicant's substantial completion of the work secured thereby.
Oh, is that typical boilerplate, Ed? Is that how
Yes.
it's held? Okay, okay,
And this was taken from the Madison Place.
okay.
4, request to reduce the surety required under conditions C2 and 3 above may be submitted as the applicable work progresses and shall include the amount of requested reduction, a list of work outstanding, and a cost estimate of the same. The amount of the surety retained shall be based on the cost estimate of the remaining work, and the surety shall be fully released upon the completion of the applicable work. 5, prior to the commencement of construction of the project site and engineering plans, finalized as necessary as provided in this decision, shall be signed and sealed by a Massachusetts professional engineer and a Massachusetts registered landscape architect, and filed with the board and the building inspector, and shall include the following. A, utilities, including on-site utility connections, to utilities in adjacent public ways which will conform to all requirements of municipal departments or private utility companies having jurisdiction and to all applicable codes. B, storm water pollution and prevention plan notes that address mitigation of sedimentation and erosion, including details relating to any temporary drainage basins. C, letter from project architect confirming that the project complies with the applicable Architectural Access Board regulations. And D, details of any temporary construction signs. 6, prior to starting any construction activity in connection with the project, the applicant and the general contractor shall hold a project pre-construction meeting with the building inspector and DPW director to review this decision. 7, prior to starting any construction activity in connection with the project, the applicant shall provide to the building commissioner, A, the company affiliation, name, address, and business telephone number of the construction superintendent available 24/7, who shall have overall responsibility for construction activities on site. B, copy of a municipal lien certificate indicating that all taxes, assessments, and charges due on the project site have been paid. C, certification from the applicant that all federal, state, and local licenses and permits required for the project construction have been obtained. D, proof that DigSafe has been notified at least 72 hours prior to the start of any site work on the project site. E, proof that street signage is in place to ensure that emergency personnel can locate the project site to provide emergency services to protect and secure the project site and construction personnel. And F, at least 48 hours written notice if any activity on the project site ceases for longer than 1 month, 48-hour written notice prior to restarting work. 8, during construction of the project, at the end of each workday, the applicant shall cause all project site erosion control measures required under any order of conditions issued for the project to be in place and shall cause all material and equipment to be reasonably secured. Prior to issuance of any of a final certificate of occupancy for the project, all debris and construction materials shall be removed and disposed of in accordance with state law and regulation. 9, blasting, if any, shall be performed in accordance with applicable law. 10, within 90 days after issuance of a final certificate of occupancy for the project, the applicant shall submit to the board 2 sets of draft as-built plans for all infrastructure improvements serving the project and located on the project site. The as-built plans shall, at a minimum, contain the following. 1, the location, size, and type of all stormwater infrastructure located on the project site, including, where applicable, the number of bottom elevation of infiltration units or stormwater storage chambers, the bottom elevation, depth, length, and width of crushed stone surrounding underground infiltration systems, the actual dimensions of any inlet-outlet control structures, and the invert elevation, size, slope, and type of all orifices, wares, inlet, and outlet control pipes, structures, and head walls. 2, location of project building foundations. 3, location, size, and types of all water services regarding serving the project and located on the project site, including gate, valves, T's, and hydrants. 4, rim elevations, location, size, type, and inverts for all drainage and sewer structures and pipes serving the project and located on the project site. And 5, layout of all surface driveways, parking areas, and pedestrian paths serving the project and located on the project site. The site engineer of record retained by the applicant shall provide a certification that the project was constructed in substantial conformance with the plans of record, and where appropriate, a written description of any material deviations from the building permit plans shall be provided, along with documentation as to how these changes meet the original intent of the plans. After review by the board, the applicant shall provide an electronic copy of the as-built plans stamped by a registered professional engineer to the town engineer. Okay, and then, Ed, you had a comment which I
I-
agree with, it's superfluously repeating what we just said.
Well, I'm not sure if it repeats what we said, but I think it's going to be covered in the eventual order of conditions.
Right, the next three paragraphs, which I won't read, which were part of that paragraph, as Ed just pointed out, were details,
I'm sorry, I didn't imply that it would be part of that.
it would be covered by it. I
No,
mean-
I don't think so. I think this was, stood on its own, but I just collapsed it because I wasn't absolutely sure, so I wanted the board to be aware of it. You can decide whether or not this language is necessary. I said it's probably not necessary because I believe an order of conditions would cover most of these, but I think it's worth reading through these, and the board can decide whether or not.
That's all three paragraphs.
All three.
So then, as an addition to paragraph 10, the following language would be something for the board's
Oh,
consideration.
this would be 11.
No, we're still in 10.
No, it's part of 10.
Oh, okay.
Yeah, it's,
Or you could make it a separate 11, but either way,
Well,
let's
yeah.
just get to the substance.
it's part of 10, I think. We'll keep it at 10.
All catch basins, detention basins, infiltration systems, and other stormwater management facilities shall be cleaned at the end of construction. Thereafter, the applicant and/or applicant's successor shall be responsible for maintaining the site's stormwater management system in accordance with generally accepted practice, as the same may from time to time change. Any further soil testing shall be done by a Massachusetts registered professional engineer who is a licensed soil evaluator who shall observe all conditions in the subsurface, stormwater, and sewer disposal areas, and shall relocate or modify the design of the facility if impervious soils or bedrock are present within the limits of the excavation, and the observation shall be witnessed by the town engineer or his designee, and if he deems it necessary for a licensed soil evaluator to be present, the applicant shall pay for the cost of this expense. During construction, the location of any and every stormwater disposal area shall be protected to prevent compaction by heavy equipment and to prevent contamination of the area with soils and materials that may reduce infiltration rates for the existing soils. Or these areas will be used as sediment basins during construction. All sediment shall be removed and basin bottom area excavated to loosen compacted areas prior to the construction of the infiltration basin as noted on the plans.
If I could interject, these have nothing to do with 10. 10 had everything to do about as-built plans. So you
Make
just,
this 11?
so you need to decide. It seems to me that it wouldn't hurt to have these in, even if, when the order of conditions is issued, it repeats some of these. You can decide that.
Why don't we just take and convert it to 10A and leave it where it
Yeah,
is? And
I would just
just
stick
put
it-
it, convert it to 10A and leave it where it is presently.
Well, when this gets edited, things may be renumbered, but what we will do is make sure that this is a separate numbered paragraph, whether it's 10A or 13, whatever it turns out to be, it'll be in there as a separate paragraph.
Great. And delete, obviously, the probably not necessary.
And also will be covered by order of conditions.
Right.
11, or whatever. Prior to commencing construction, the applicant's final construction plans shall provide that the construction of the project shall be performed in accordance with all applicable laws and regulations regarding noise, vibration, dust, sedimentation control, and blocking of town roads, and the applicant shall install aprons at entry points and provide for dust control in the form of sweeping and spraying of water whenever necessary. 12, there shall be no exterior construction activity, including fueling of vehicles and delivery of construction materials and equipment on the project site before 7 a.m. and after 6 p.m., Monday through Friday, and before 8:30 a.m. or after 4:30 p.m. on Saturday. There shall be no construction on the premises on the following days unless a special approval for such work has been issued by the Southborough Police Department. Sundays or the following legal holidays: New Year's Day, Memorial Day, July 4th, Labor Day, Thanksgiving, and Christmas. The applicant agrees that the hours of operation shall be enforceable by the Southborough Police Department. 13, during construction of the project, all project construction access and egress, including the removal or delivery of materials to or from the project site, shall be limited to Park Central Drive, and the applicant will arrange for reasonably necessary police, traffic control, and construction signage in connection with the foregoing. 14, any portion of Flag Road or Blackthorn Road that is damaged by the project's construction activities shall be repaired to substantially the same condition as existed prior to such damage. 15, during the period of construction of the project, the applicant shall sweep that portion of Flag Road or Blackthorn Drive adjacent to the project site whenever reasonably necessary due to dust and debris caused by the project's construction activities. 16, during the period of construction of the project, no project vehicles of construction, workers, and no project construction vehicles or equipment shall be parked on Flag Road or Blackthorn Drive or any other public way of the town. 17, during the period of construction and marketing of the project, notwithstanding any preconditions for the issuance of a building permit or certificate of occupancy otherwise set forth herein, the applicant shall be entitled to designate, construct, and operate one of the apartments units as a decorated model unit. The model unit and sales office shall be subject to the usual requirements of the building inspector with respect to building and fire code compliance. 18, during the period of construction of the project, the applicant shall be allowed to locate 2 construction trailers on the project site, provided, however, that the trailer shall not be located within any zoning-related setback area. 19, during the period of construction of the property shall be secured in a manner approved by the building inspector so as to prevent personal injury or property damage. 20, during the period of construction of the project, no construction materials, including but not limited to building materials, fill material, or landscaping materials, shall be stored on the project site during construction of the project in excess of those materials to be used for the construction of the project during the next 365 days unless otherwise approved by the building inspector. 21, during the period of construction of the project, the applicant shall employ industry-best dust control procedures on a daily or more frequently as necessary basis to minimize construction-related dust moving off of the project site. 22, during the period of construction of the project, the applicant will ensure that no construction activity occurs on any abutting property outside the overall site. 23, as-
Just slow down a little bit.
okay,
Couple questions. The makeup of the property, as far as the condition of the soil, are you gonna be removing loam from the property? Is there what is the makeup of this property?
A lot of it's been stripped when Flatley started his work. I mean, there is some loom there, we're gonna need some, we're probably gonna,
We'll probably,
utilize a lot of it.
all right, so if you're planning on removing excess loam off the property, you'll need to get a permit for that, right? I think,
That's a standard process through the town.
Right.
Which this project had already been in front of the town for that prior, last year or 2 years
I think
ago.
there's an earth removal permit.
And
that's
moving and
selecting
bringing
issues.
material on the site already approved by the Board of Selectmen. That's already been done.
okay, just wanna make sure. And then, with regards to ledge on the property, have you done any boring tests? Okay.
We did probably 4 dozen borings, we've not shown any signs of ledge, doesn't mean that there isn't any. There really aren't any big cuts other than,
Yeah, because I know,
Access road.
a few back, you mentioned blasting, and I
Yeah.
saw some of the neighbors
right, I mean, I
kind of
think
freak
that's
out a
just
little
a
bit.
standard.
So,
we're-
it's just,
we're-
I know it's boilerplate, I just wanted to get your
We're not
feedback.
encountering any.
Okay.
I mean, if we do hit it, it'll be just on that access road coming off a Flag going up there.
What is applicable law for blasting then?
I mean, you gotta meet state standards.
So there's a
The
state,
state fire marshal
there's a state law then,
has
Exactly.
requirements that are about an inch thick of
that's the state.
state.
Okay.
All right, so, okay, I just want the public to understand that you haven't experienced any ledge,
We're not anticipating any.
and you're not anticipating any. But if you do, you'll follow the, obviously, the
have to
state,
meet the
the
state
state required.
Standards, yep.
Yep, okay. Any other questions up to now? By the way, is there any, if any board has any questions with anything that's gone on, or, sure, go
As far
ahead.
as blasting goes, there was another recent project that was nearby to me, and blasting is not very noticeable, actually.
Yeah.
I mean, it was well notified,
Yep.
so all the neighbors, all the abutters were notified, and you'd be hard pressed to notice it was going on, so this isn't,
Sounds worse than it is.
Yeah, I understand. Yes, Mr. Jenks, sure.
Phil Jenks, Planning Board. Couple of easy ones. On page 12, item 4, your list of various items. Item B, stormwater management facility. Can you define facility a little bit? What is that? Is that like a wastewater facility? Is,
That retention ponds?
It's the entire drainage infrastructure.
What if we substituted system for facility?
Sure.
or infrastructure even.
and that comes up again, I didn't get it, but it is the system, then it is not a structure or a particular building, or,
Correct.
It's not a building, but it may involve certain.
yeah, it may involve
Structures.
structure,
Yeah,
sure,
it could be a vortex system. I think there's a couple of vortex systems in there.
okay. Oh, here it is again on page 18, in that probably not necessary section.
Feel free to check.
And I don't know if it makes any difference to you, but I'll point out in the couple of places on that page, you talk about a Massachusetts registered professional engineer who is a licensed soil evaluator. The Division of Registration of Professional Engineers does not license soil evaluators. That's a DEP designation. I think that is it. Thank you.
Jack, what page was it, what,
Page 18,
18?
in the section labeled probably not necessary.
Gotcha, thanks.
So do we want a Massachusetts registered professional engineer who is also a DEP licensed soil evaluator? Or would it suffice to have a DEP licensed soil evaluator?
I think they're two different indications. So the soil evaluator would be doing the soil evaluating. You said if we need additional test pits, so a soil evaluator would do the additional test pits if required.
So would you say then that we want a Massachusetts registered professional engineer and a DEP licensed
Soil
soil
evaluator.
evaluator?
Yep.
Right, okay.
Mr. Chairman, I am going to make a motion that we have a quick 5-minute recess, please.
Second? I can, he wants to make a 5-minute
Quick
recess.
5-minute recess.
Sure.
Okay,
Second it?
I second that.
okay. Discussion?
Favor? Aye.
Okay. We're gonna have a 5-minute recess. We'll be back at 20 of.
Go ahead.
Okay, recess is over, and we want to continue with,
Mr. Catanzaro.
what number, what,
We left off the,
what, we left off, right, Mr. Morris would like a comment after Mr. Jenks. Go ahead.
Right, just responding to your question, if any of the board members had any questions.
And we just went through C, I'm referring to C13, which was during construction of the project. It talks about access and egress be limited to Park Central Drive. And then 15, during the period of construction of the project, the applicant shall sweep that portion of Flag Road or Blackthorn adjacent to the project site whenever reasonably necessary due to dust and debris caused by the project's construction activities. So if we're keeping all of the construction-related traffic on Park Central, why would there be a need to sweep Flag or Blackthorn?
Because Blackthorn, we're extending the water line, which is at the end of the cul-de-sac, so we'd have to cut into the cul-de-sac. And on Flag, we're gonna be cutting in the new access road, and I'm gonna be reworking the end of Flag Road on Route 9. So during those specific construction activities, the street sweeping will be required.
Okay, I think that clears that up. So, you mentioned constructing the connection to Flag Road. Once that's constructed, is there any provision to enforce number 13, which is to limit all the traffic to Park Central? What I'm getting at is, you can build that connection, I guess, anytime you want, or anytime the DPW allows you to, make that connection. But once it's made, if it's made on the last day, then it pretty much assures that no construction-related traffic will be needing to get onto Flag Road.
Yeah.
But
Yep.
if it's constructed on the first day or the early part of the project, what method of controlling the access outlined in number 13?
Well, we plan on going in from Flag and starting and working our way up the hill. Once that portion is done, we would block it off. The intent is to have.
Wait, so you're gonna start from Flag and work your way up, you're not gonna come down, you're not gonna go through Park Central and work your way down to Flag Road?
No, because most of the work is getting from Flag up to Park Central Drive.
To get into the
That's where the
project.
cuts are, that's where the
Okay.
brook
All right,
crossing is and everything else.
So our concern is limiting construction vehicles on that Flag Road.
Right, so once that road is constructed, we're not gonna allow people to go in and out of Flag. We're still gonna have all the construction traffic going out of Park Central. Once, again, this is not a 1 or 2, it's a 3 or 4 year project. Flag, the connector road will be limited to residential use only. During this construction period, the contractors are still gonna use Park Central Drive.
Right, but I guess my question is, and I'm sorry to take away some of your steam, but I think that,
You go-
I think
go
your
ahead.
point is well taken. During the initial phase, when you're cutting in to that access off of Flag Road, you're gonna be bringing out, debris, stumps, whatever, to cut into that road, and it's all gonna
No, most of that
go out
can.
onto Flag Road,
No,
or is
no,
it gonna?
it can go off through Park Central.
Okay, I guess.
I'm not saying all of it, but I'd say 90% of it, they can take up through Park Central.
Except that we put a condition in there.
Yeah,
And we had discussed prior to this too, is that the access on the Flag Road will not go until he get an occupancy permit on the 40B project. So until he gets an occupancy permit, there will be no traffic going out on that access.
Except for the construction of the
Well, yeah, but
road.
we're talking about construction now. We're
Construction
talking about the
is
initial.
all through Park
Right.
Central.
I'm sorry, Mr. Morris, you have any other questions or comments?
Well, it could be that on day one, the low bed goes up through Flag Road with the bulldozer and the grader and the dump trucks. And for the first day, or the first week, or the first month, all of this stuff is happening on Flag Road. And I think the intention on number 13 is to have 0 on Flag Road. So either we change this, or we find some type of language that prevents what I just described from happening on Flag Road, since it can be accessed from Route 9. And if during that period, first day, the first week, the first month, when those the heavy equipment, the hauling, stumps, all that stuff, the trucks, the pickups, just the workers' vehicles, should somehow be prevented from using Flag Road
Well,
from either direction.
hang on. What he's saying, if you looked at the plans, doesn't make sense. You have a culvert in the middle of the access road. You can't get to it. You have to construct it from both sides and put the
Understand.
bridge in. You can't build a bridge from one side. So
right,
that's what
so
he's
I
looking
guess-
to do.
I guess Mr. Morris's point is that we don't want to have it open-ended.
No, I agree.
And, because we don't want the day or week or month to turn into 6 months and a year, and because they're.
Nope.
So, once that initial culvert and once they get to the point where it meets up with Park Central Drive, we can't let, I guess we can't let, at some point, when you say no construction traffic on Flag Road, I understand that initially, you need some access to, off of Flag Road for dozers and,
Just to construct that access, what I was talking about construction traffic, the building of the units and the apartment buildings.
right.
You know,
Yeah,
that
right,
is what
right,
I was talking
Right,
about.
so
Some
I think
language
I'm
like
on the
road
same
work
page
only then,
as Mr. Morris when we're talking about the earth-moving equipment to cut that road.
The roadway construction.
Right.
Correct.
So I think we should try to use some language in a condition that minimizes the impact to the neighborhood on that initial, because you've already agreed that you're gonna run, during the building phase, you're gonna run everything through Park Central.
Correct.
So I think we should have some type of language during the initial curb cut off of Flag Road and up to create the John Bolin Road, John Bolin Drive, that we have some language to I guess, minimize the impact to the neighborhood. So I'm open to some suggestions. I know it's hard to put a hard number on that.
Excuse me, there's a section, at least it was in the version that we had earlier this afternoon, the version that we just received, wasn't able to plow ahead on it, but there was a provision in the edition before this that talked about a pre-construction conference, pre-construction meeting.
That's in here.
Yeah, we did read that, I don't have it in
So-
front of
It's
me.
further back.
So, Sorry, Dan. it may be that, you know, at the time that whoever is gonna construct this has their more detailed plan, coordinate it with the neighbors and the public safety, so that there's a clear understanding of how and when and how long. It may be accomplished with a text within that, so that the neighbors would know.
Well, what's a reasonable period that it would take for you to do this, Bill? Like, what would be a reasonable period that you would need that Flag Road access?
Well, only until we're past the culvert. Once the culvert's in, we don't need it anymore. But I have to build it from both ends.
Okay, no, I get that.
And I can't, depending what time of the year is, if we do hit ledge right, that's the spot that we would hit it.
I mean, some language,
Oh, we-
subject to road work up to the culvert.
All we need to do is add to a condition stating that, number one, there is no traffic on Flag Road except for the new intersection, so nobody can go, they can't go down Flag Road at all left. Everything will be just Flag Road to Route 9, till the entrance and exit out through that area during the construction of that end of the road, period. And just
Right, so-
add that to the condition and be done with it.
Right, because
Simple.
once the dozers and excavators are on that property, they're not going to be going back onto
No.
Flag Road.
No.
So any debris, any type of trucking, anything that is related to the project on that street, any stumps or ledge or anything that you have to move off the property, we would like you to take a right off onto Flag Road and onto Route 9.
Of course.
So
yeah.
none of that stuff can go
There's
down.
no,
Flag.
no construction
Okay.
traffic, whether it's roadway or building,
Got it. All
goes
right.
left.
Okay, so I'm fine with.
Let me try some language. Construction traffic necessary to,
Hang on, Ed, you're on number what?
I'm just saying,
Oh, okay, I saw your finger on something.
Press your mic.
construction traffic necessary to complete the improvements on Flag Road, necessary on Flag Road Is it just Flag Road?
No, it's John Bolin
And John Bolin
up to the culvert crossing.
shall be limited to the time period required to complete such improvements. Furthermore, any construction traffic shall not go beyond the
John Bolin Road.
intersection of Flag Road
John Bolin Road,
and John Bolin Road.
not beyond John Bolin Road.
Okay.
Right. So basically, that would eliminate any construction vehicle from going north of
John Bolin.
John Bolin on Flag,
All right.
including even in the initial phase.
Correct.
Okay. Excuse me? Wait,
No,
no, I'm sorry.
No means no.
that's
No
it.
means no.
Let's go forward.
Okay, continue on. What number are we at?
If I just need to make a note on what we're talking about so we can get the change in.
So this will be a new condition.
I know, but I'm just writing it.
I've lost track of the numbers where we're at.
Me too.
No, we're on page 20, and we're going to pick up with number 22,
Okay,
but I'm just writing down what
Go ahead.
you gentlemen have discussed so that we can include it.
Mr. Canzaro, I appreciate if you could go forward and write it down after, because we have 10 minutes and we're going to have to go into an executive session, and you'll have a half hour to do all this.
A half an hour, thank you. The 22, during the period of construction of the project, the applicant will ensure that no construction activity occurs on any abutting property outside of the overall site. 23, as part of the construction process, the applicant will conduct appropriate tests of the water system to confirm that the necessary water flow is available to meet applicable ISO and NFPA standards. Such tests will be conducted during peak demand times, and the results of such tests shall demonstrate the applicable requirements, that the applicable requirements are met. 24, the town fire chief will conduct standard plan review prior to issuance of a building permit for the project, and any deficiencies with the NFPA,
13, add 13.
NFPA 13?
Yep.
NFPA 13 standards identified during the review shall be corrected by the applicant as and to the extent required pursuant to such standard. In addition, the fire chief shall perform the standard inspection for smoke detectors, carbon monoxide detectors, and oil burner and/or propane inspections before the issuance of any certificate of occupancy for any building in the project, and any deficiencies with applicable requirements identified during this review shall be corrected by the applicant. 25, design and construction of the project shall fully comply with all applicable federal and state law regulations, including but not limited to the Massachusetts State Building Code. The project shall be designed and constructed on the project site in accordance with the plans of record, except as otherwise provided in this decision. Construction documents for the project shall undergo the usual and customary review and approvals of the building inspector, the Board of Health, the Fire Department, or any other applicable town board or commission solely to ensure compliance with this decision. Construction of the project shall be subject to on-site compliance inspections by the building department in the customary manner. 27, landscaping of the project shall be substantially in conformance with the plans of record, except as otherwise provided in the conditions. Landscaping on the project site, as shown on the plans of record, shall be maintained, repaired, or replaced by the applicant or his successor as needed to maintain substantial compliance with the plans of record. 28, the width of the connector road shall be no less than 22 feet as shown on the plans of record, and subject to the waivers granted by this board, be constructed to subdivision road standards. Okay,
Up there.
and Ed, you had added other thing, but the next sentence pertains to the townhomes.
Right, and I
no
think that can be deleted
Yeah.
from this.
So the second sentence in 28 delete?
Yes,
Okay.
because it refers to the townhouse condominium. And I wasn't sure, and
Subject
if
to waiver.
Angelo says it can be deleted, that's fine. I have some minor comments on number 23. Will you make those wills shalls? And, do you see that, Angelo?
Nope.
Number 23. It's just editorial.
3 or 28?
23.
23, applicant shall,
Oh, you're going back?
Oh, yeah, I see, yep.
I'm going back, and such test shall.
You got that, Joe?
And on number 26, it just reminded me, very often on 40B comprehensive permits, the ZBA also has its peer review engineer monitor certain parts of construction. I'm not sure what the intent is here. This implies that the town is going to do all of that.
What number are we at?
I'm sorry, I'm on 26 on page 20. I'm going backwards here. There probably should be some language that says, to the extent, shall we say, on-site compliance inspection by the building department, or its designee, or the ZBA's designee.
So it's like a clerk of the works?
Well, not a clerk of the works.
Okay.
This is simply, boards expect the peer review engineer who reviewed the plans and knows the plans sometimes gets involved with monitoring construction. Not always, but sometimes. I can probably find during the break, or during your executive session, I'll look for some language in
Okay.
other 40B
All right, so we can-
decisions.
we can read.
Or Fuss and O'Neill might have some language on that.
And you would want to be inserting that where? In
26.
26 probably.
26C. Section C 26.
It's not unusual to have it.
Mr. Monchon, look up under Madison Place, because it was done by the building inspector through Madison Place's engineering that did the reports and as a consultant for the, what do you call, it? But
Of
it
course,
was
this is
done,
controlled
that's
construction.
the way Madison
Right.
Place was
So
done.
we were gonna have the engineer of record do inspections and then do affidavits at the end of the project.
Right.
Under, typical controlled construction.
And the thing that made that easy was for the building inspector, that if there was something going on during construction or whatever, he could get a hold of them immediately on site and be able to find out whatever his questions are or whatever as he's reviewing what's going on at the time.
So, Mr. Petrie, what was, you're saying, your engineer is gonna
Well, we were gonna do it
certify
as
that?
a controlled construction project where the engineer of record basically oversees the work, and at the end, he's gotta sign an affidavit stating that he was there, saw it was constructed, and he certifies that it was done according to the plans.
This
And
project
that's-
is of a size where the developer doesn't have a choice. It has to be done under controlled construction. Controlled construction requires a minimum number of visits to the site by either the project architect, I believe, or engineer, who files reports with the building inspector.
Right.
It was the engineer
I
at
think on a
Madison
monthly,
Place.
I think on a monthly basis.
It would be both on this project because of the size of it.
So would that be the applicant's engineer instead of a
Yes.
peer
Yes.
review?
Well, it'd be the applicant's engineer, but I've seen even, there's just a general clause.
It's
That-
it's an accepted practice to
Right.
do that.
So I'm going to look that language up in another decision if I can during the break.
I mean, as a request of the building inspector.
What number are we on now? So we're on-
We're gonna do, we'll do one more, and then we'll have to make that break.
Okay, well, we're going to need to discuss on 28 also, so it's going to read, "The width of the connector road shall be no less than
All right, we still
22
have to stop at
feet
7.
as shown on the plans of record, period." Because the subdivision has been waived. I don't think I don't know why that's in there.
This is on 28?
Yeah, we're on 28. The width of the connector, it should be just referring to the connector road. You follow me, Ed?
Yes, what's
Okay.
what's the width of the connector road shown on the plans of record?
22.
22.
Well, if that's the case, I don't know why we need this at all then.
Just, yeah.
I know.
I mean, the connector road, you're right, you can get rid of the whole piece of it. The whole number 28.
So as long as we're not referring to the spur road, then
No,
we
we're
don't
not.
need this.
Okay, so we can eliminate 28?
Yeah.
Okay.
Okay, and one more. Do you want to do one more?
You know
Mr.
what,
Chairman.
it's 7 o'clock. I think that we're gonna,
I'll make the motion. We make a motion to continue this close the public hearing, continue the public hearing until 7:30
Why
this
don't
evening.
not close the public
No,
hearing?
continue it till 7:30.
All right, any discussion? A second first?
I'll second that.
Okay, any discussion? So we're going to continue this public hearing at 7:30. We're going to break into executive session until then, and we'll start up right where we left off.
Thank you.
Do we leave or do we stay?
Every-
We are now reconvening the public hearing for Park Central, and we're going to continue on with the order of conditions draft.
As we left off,
29.
We are on, I think, 29.
right, page 21,
Page 21, number 29.
29, all drainage, culverts, underground utilities, and chambers located under any roadway on the project site shall be designed as to ASHTO H-20 and HS-20 weight loading standards in order to safely accommodate emergency vehicles. Period. This one is a new addition, Ed. This is number 30 on page 21. I think it's, as it applies to the connector road, I think it's applicable, but as it applies to the townhouse roads, I don't think it is. I'll just read it. It says access along, and I believe it means, it should say connector road, or maybe John Bolin Road. Access along John Bolin Road, and access drives from the connector road into the townhouse component shall meet a minimum height clearance of 15 feet to allow for proper ingress and egress of emergency vehicles.
I didn't understand that one at all.
Okay.
I mean, there's no overhead construction that you drive.
Well, I understand that. I just don't know whether if this was a concern of who inserted this or
Yeah, where did this
or
come
why.
from?
And,
I don't think it's applicable for this project. I mean, if you're driving under.
is it something that the fire department wanted? I mean, I don't know.
I did not insert this. This is on a draft I had reviewed.
What's that? Came what?
Bob Moss's.
It
Oh,
might
it
have
did.
been
So this was from,
in the original draft,
okay.
so
So this
Yeah, I
is,
mean, right, I think there could be some looping over lights, or trees, or maybe it was referring to that. I guess the idea is, the fire department's saying they need 15 feet height clearance for their apparatus, so,
I think they would want more than that even.
well, 15 feet on the roadway, as it,
Yeah.
as, I think that's, 13.6 is legal height, so they're asking for 15 feet.
do we
think that's-
object to 15 feet? I mean,
Yeah,
we could-
all right,
we-
so
we
I
could
don't have
put
I mean, I think you
minimum
should just
height-
leave it in there, saying all the roads on the project should have a minimum of 15 feet of clearance height.
No problem.
So just strike the along and the connector.
Yeah,
road
I would just
from
say all roads.
All roads,
All roads in the project
Of roadways within. the
shall have a
project.
minimum clearance height of 15 feet.
Is this for the, it's just the townhouse component, so is that not what we're discussing
No,
anyways?
no,
we
it's
should do it
every,
as David said, all roads in the project.
Yeah.
We're
Just call it
talking
the
about
project.
the project.
yeah, because it's a defined term, the
Yep.
Right,
project.
so strike townhouse
Right,
component too then.
absolutely.
so it's going to read now, all roads within the project shall have a minimum height clearance of 15 feet to allow for proper ingress, egress of emergency vehicles.
Yeah.
That's the way that will read?
You got that, Joe? Okay.
Okay. 31, building address and numbering shall be as reasonably specified by the applicant in consultation with and with the approval of the town fire chief. 32, fire lanes denoted on the plans of record shall be marked no parking, quote, no parking, comma, fire lane by signs and/or by marking on the pavement. Such marking shall be maintained so as to be clearly readable by residents and visitors. Restrictions on resident and guest parking at any time in any area designated as a fire lane and specific penalties for violation of such restrictions shall be included in the condominium documents. 33.
And we should, again, that's going to be confusing. I understand that this is being developed as a condominium with a rental unit and a for-sale unit. We should reference leasing. We want to have this in the leasing documents for the project.
Rather than the,
In the,
rather than the condominium documents.
Yeah.
both,
Or is it leasing and condominium documents?
leasing and condominium.
Well, wouldn't,
But the residents are not going to be reviewing the condominium documents. They're going to be reviewing the lease.
wouldn't just leasing suffice then?
It
Because-
makes it a little stronger if you have it in the condominium documents also.
And we have no
I
problem
think
with
if
it
you had
being
it in
in
the
the
leasing
condominium
and
documents.
condominium documents, that would be better.
Right, and I just want to go on record on number 32, which we're on, is referring to no parking signs, fire lanes, and the enforcement of these fire lanes and no parking areas. Obviously, we're gonna circle back to this later when we talk about, other type of signage and how we're gonna try to enforce it. So this is an acceptable way to kind of police it by putting these fire and no parking, fire zone, no parking signs up. There's an assumption that it would be adhered to.
And I think probably it makes sense. You reminded me that the applicant shall be responsible for enforcing these requirements.
The thing is, you have to understand that under 32, it is required by the police and fire chief. That's a specific requirement for them on these issues. They're the ones that requested it.
They'll have the requirements.
Right.
I'm not sure you could expect the town police to come onto this property and enforce them. Will the town police come onto private property and
It's
enforce these?
the fire chief is the one that did this. Because the fire department goes on this property all the time, and the police department would have to go on there for emergency access.
Right, I mean,
But I understand that. I just like belts and suspenders on something like this because it is a public safety issue.
And any-
I would simply say that in addition to enforcement by Town of Southborough public safety departments, the applicant shall also enforce these provisions.
Yeah, he has to enforce it.
okay.
Okay?
But the other ones have to go
All right,
separate.
so 33?
33, resident pedestrian access to conservation land to be provided.
That's resident of the project.
Yes.
Yes.
So it should say project resident pedestrian access.
Shall be provided.
D, wetlands and stormwater. 1, the project requires the issuance of an order of conditions by the Southborough Conservation Commission and/or superseding order of conditions issued by Mass DEP pursuant to the Massachusetts Wetlands Protection Act and implementing regulations, parens 310 CMR 10.00 et sec, and shall comply with the DEP stormwater policy. Any changes required in the project as a result of the issuance of an order of conditions or superseding order of conditions shall be reviewed by the board pursuant to applicable DHCD regulations. 2, The project's stormwater drainage system shall be operated and maintained in accordance with the plans of record and the stormwater drainage report and analysis submitted by the applicant to the Conservation Commission and as approved in the final order of conditions or superseding order of conditions. 3, the applicant shall provide a stormwater and erosion control management plan for the project satisfactory to the building inspector before issuance of a building permit for any work on the project site as to the extent required under the project's final order of conditions or superseding order of conditions. 4, the use of sand, salt, or other similar treatments shall be minimized to the extent practicable, considering public safety, consistent with the project's final order of conditions or superseding order of conditions. 5,
Wait, I thought that in a previous meeting, we talked about no salt. No?
No, magic salt.
Magic salt? Environmentally safe?
Yeah, exactly.
Okay.
Yep.
So maybe we should reword that
Right.
to talk about, because you're saying minimize salt, that,
Well, there's the volume of it.
yeah, I know, but I don't like the word just salt. I think that,
Magic, is that
is that a,
known industry product?
or we could call it salt substitute.
yeah, I would call it, even go further, and I would say environmentally
Friendly.
friendly salt substitute. Because,
Something for dinner.
Mr. Pasamato, if you'd like to make a comment about that?
They'll have it in the order of conditions, too.
Okay.
Mark Pasamato. So the Conservation Commission order conditions will definitely have a condition regarding what materials they can and cannot put down on the road for
Okay.
for snow and ice management. So,
Okay, as long as, all right, I just want, all right,
So
so
come under
they-
the conditions, that would be all
they'll
right.
they'll be covered twice, I guess.
So,
That's
It does
fine.
say or similar treatment, so I think that's,
Right.
that
Okay.
kind of
well, the
covers.
way I've changed it is the use of sand, comma, environmentally friendly salt substitute or other similar treatment shall be minimized to the extent practicable, considering public safety, consistent with the project's final order of conditions or superseding order of
That's
conditions.
great. Thank you.
5, prior to the issuance of the first building permit for any building within the project, the applicant's registered professional engineer shall prepare a stormwater operations and maintenance plan for a final commissioning and long-term maintenance program as and to the extent required under the project's final order of conditions or superseding order of conditions.
I'm fine with that.
E, wastewater treatment facilities.
Before you begin on that, there were just a couple typos I want to make sure you caught. There were
The,
two superfluous, these in 3, the final order,
right, I got those in them.
and in 5.
Yep. Wastewater treatment facilities. Prior to construction of the project, the applicant shall provide the board with a copy of a valid groundwater discharge permit issued by DEP for the wastewater treatment plant. 2, the location of the wastewater treatment plant and related appurtenances shall be where so indicated on the wastewater treatment plans approved by DEP with all process-related equipment contained within buildings. 3, access to the wastewater treatment plant for maintenance and emergency access shall be provided and maintained as shown on the plans of record. 4, any hazardous materials used in conjunction with the wastewater treatment plant operation shall be subject to a spill containment plan approved by the fire department and/or DEP. 5, the design of the wastewater treatment plant shall provide for the elimination of detectable odors in or from occupied residential buildings as determined by DEP. 6, the fire department shall be notified immediately by phone, and the Board of Health shall be notified forthwith in writing of any inadvertent release of contaminants or untreated effluent from the wastewater treatment plant. 7, no wastewater treatment plant construction shall commence until detailed construction plans and specifications have been reviewed and have received final approval from Mass DEP. Special,
Wait, excuse me.
yep,
Mr. Morris, you want to make a comment or a question?
I wanted to go back to D, D3.
It's a little bit out of the planning world, but because of our discussions with our highly professional building inspector relative to open space, he's let it be known to the planning department that his expertise is related to buildings and structures. And in this case, D3 requires the stormwater and erosion control management plan to be satisfactory to the building inspector. So it just popped into my head that he has told us that this is an area that he's not that comfortable with managing. So I'm wondering if you changed it to satisfactory to the Conservation Commission before issuance of a building permit. Well, issuance of a building permit is by the building inspector, but it would seem, and I, defer to Concom, but it would just seem that their expertise would be more toward the stormwater and erosion control management plan, rather than the building inspector.
This is related to the prior comment I made. I actually found the language in a recent comprehensive permit decision where if town staff doesn't think it has the experience necessary to do a review, the peer reviewer very often is asked to do that. Could you read that language that I just gave you?
Excuse me, use that mic.
The applicant shall pay?
Right.
That one. The applicant shall pay all of the board's and town's prior and outstanding peer review and consulting fees, if any, within 30 days of the issuance of the comprehensive permit. The applicant shall pay for all post-comprehensive permit peer review, post-comprehensive permit inspections, and post-comprehensive permit legal fees by establishing or continuing the escrow account now established pursuant to GL Chapter 44, Section 53G. No occupancy permit shall issue if an outstanding bill for any fee is 30 days overdue.
So that gives you the general. So I think you've got a couple of options. You could keep it with the building inspector. You could engage the engineering peer reviewer who's very familiar with the project, or you could delegate it to another board.
Well, could you have it with the building inspector with consultation with the, Conservation Commission?
Right, or with the peer reviewer, anyway.
Mr. Passamano?
So with respect to the NOI for Park Central that's in front of the Conservation Commission, the NOI is for the Wetlands Protection Act and the stormwater policy per the Wetlands Protection Act, or the DEP policy. So to that end, we have hired Fuss O'Neill as a consultant to review the stormwater management, and they will be going through the stormwater management, control management plan and erosion for this project. And that will be part of our order of conditions when we get to the point of issuing that. And Lucas Environmental will be reviewing the wetlands impact with respect to Park Central. One of the areas where the building inspector has felt uncomfortable with stormwater management has to do with the Southborough stormwater management or stormwater bylaw, which is a zoning bylaw in the town, and you folks have waived that for this project. So, with respect to the NOI and the DEP stormwater policy, we'll be relying on Fuss O'Neill and specifically Dan Delaney behind me to do that review, if that helps.
Okay, so we can add some language maybe to allow the building inspector to defer to the,
Or we could just change it to the
Here.
Conservation Commission, and they can delegate internally how
Yeah.
they.
we
how
can say
they
the
want
building
to-
inspector or
Or
his
his
designate.
designate.
The building inspector designate.
To the building inspector, or, because
Or-
we want to know where we have to go with
I
it.
understand.
Yeah, but I know, like, Mr. Morris's comment is if the building inspector just isn't qualified for
Right,
that,
but
you
we're
don't want him just
giving
saying
him the
yay when
authority
he doesn't.
to assign the responsibility to a.
Yeah, but what if he chooses not to and just says yay?
Yeah, but see, his
Mr.
job is to review all these different items. So to give him the authority, he can send it to where he wants to send it to get it done.
But
Yes.
did I hear the applicant's counsel say that he didn't have an issue with it going to the Conservation Commission for that review?
Right, yeah, he mentioned
We-
he had no
no.
issue with it.
We don't, because I rewrote it, Attorney Cipriano, as the building inspector or his designee, or we could say to the Conservation Commission. I mean,
I would say the better approach would be the Conservation Commission or their designee, which could be their engineering group. I think that's the appropriate place,
All right,
because
so
a
cut
building
cut the
commissioner.
building inspector out of the loop.
Yeah, because a building commissioner.
I understand.
He has extremely limited, respectfully, understanding, it's all building permits and perimeter drains relative to a house.
Okay.
I know that this building commissioner doesn't want that responsibility. It properly should be with the Concom or their designee engineers.
Okay, you got that, Joe? Well, okay,
I got it.
okay. All right, so let's move on to,
Special conditions.
We're now back to
let's see, where are we?
page 23, special conditions.
Special conditions, F.
Okay. These were conditions that were the result of recent communications and recent discussions, I mean, not recent discussions, but discussions that have been ongoing, but they're not really drafted finally, because that was something that was being left to the board. But I think the subject matter is covered here, and what we're gonna need to do is to get specific language that satisfies the board as to these conditions. So I'll just start the way that they're listed in here, F, and I'm just gonna give it a number because it doesn't have a number. The one, special conditions, one, applicant shall install, quote, no right turn directional signs at the exit from both the Red Roof Inn and Cumberland Farms onto Park Central Drive so as to discourage customers, employees of both businesses from using John Boland, Drive as a cut through to Flag Road. I think it's John Boland Road. Road, as a cut through. So these were the signs, Mr. Chairman, that you had mentioned, exiting from both of those businesses so as to prevent people from taking a right to go up into the project from those businesses. We don't have a problem with that. I just don't know
Okay, so,
if it's gonna work.
go ahead.
To clarify, that would be on Park Central Drive.
Right.
Because you don't own the properties,
Correct.
Right,
so you can't
It would be in our.
put a
meeting-
condition in to put something
It
on
would
the
be in
property
an
you don't own.
appropriate location on which we do own
so
the
there'll be
property.
multiple signs, one for Red Roof and one for
Yeah, because there's
Cumbies.
two different, there's two
Exactly.
different
Okay.
areas.
I have no, I mean, this was something that I thought of. I think it's fine the way it's crafted, unless anyone wants to tweak it a little bit. Does the planning board have any opinion on this? Okay, we're gonna move forward. Okay,
two.
that's fine.
The project, the project's Park Central Drive entry shall include signage indicating that such entry is subject to use only by the overall site's residents, guests, prospective residents, and other invitees.
We're just confused where that goes. It's a sign, I don't, but, where would it get placed?
It would have to be, as you, probably just, I would say just past Red Roof, maybe before you get into the John Boland Road.
So probably just past the office building at that point there?
Right.
Okay, so just past the office building.
And I would actually put two of them, one on either side of the road.
Yeah.
So we'd say as close as possible to the office building?
I said
Yeah,
It should be just north of the office
Just
building entrance.
north.
right.
appropriately located to the north of the office building.
And it should be one on either side of the road.
How about immediately north of the office building?
Okay?
Okay.
The, I'm gonna skip over,
There's Red Roof, so like anywhere here,
Yeah, exactly.
anywhere there is.
there's a notation in here about left turn at Flag. We'll return to that one because there's no substance here. Let's go through the ones that are written.
Okay.
And then we can return to whatever condition the board is thinking about with respect to Flag Road. 3, prior to the issuance of a building permit for the project, the applicant shall deposit $25,000 into escrow with the town to be available for use by the town to design and construct traffic calming measures such as sipped humps, sidewalks, street lighting, and signage on Flag Road. Any such funds remaining in escrow on the date that is 36 months after the applicant has deposited the same into escrow shall be released to the applicant. We have 2 issues with this condition, which we just saw recently. One of them is that we don't object to the $25,000, and we don't object to it being placed in escrow. However, we would much prefer that I be the escrow agent, and the funds would be released pursuant to an escrow agreement that we would enter with the town at the time that we place the money in escrow. And 2, that the money be used for the construction of the calming devices, not for the design. This way, if the town decides that they want them on Flag Road, and I would assume, okay, that's where these off-site mitigation devices would go, would be on Flag Road. If the town wants them,
All right,
and they're
so
designed, we'll pay up to $25,000 to install them.
as most everyone knows, we have no jurisdiction over any upgrades or changes to Flag Road. That's up to the selectmen, and I know that many of you saw last night's meeting, and they did discuss the Flag Road, and that's really their realm. We're not going to be able to force anything onto the development with regards to changes to Flag Road. But having said that, I think
I don't know what it is.
I have 2 issues with this. Number one, I don't understand why the town can't hold that in escrow. That's number one. And number 2, I have a problem with the 36-month limit, because if the project is going to take potentially 3 years to build, and you put this money in at the beginning, and it's built out over 3 or 4 years, you could, in effect, get your money back before the project even is over, and we don't know if it's going to be needed or not needed. So
Also, I don't mind doing 5 years, I just don't want it sitting there in perpetuity.
I was
get
gonna
it,
say
but-
from our last meeting that the traffic needs to be monitored for 5 years.
Yeah,
So maybe it should be.
I think
I'm
5
okay
years.
with
Coincide with
All
the
right,
5
so
years.
36
That
months
was our
is-
rationale there.
Right.
And, look, Mr. Chairman, I'm giving the 25,000. Trying to get money back from the town is like trying to get money out of Fort Knox. I just don't want to deal with it. If the town doesn't use the money after 5 years, I call Angelo, he sends a letter to town council, the money's released. For me to get it out of town, it takes an act of Congress. I just don't
So
want
have
to
you
go
had, in past projects, if you...
Yes, yep.
Okay,
It's just-
I'm not familiar with
It's
that.
just a rat race. And
Okay.
it's just the way they do it.
How does the rest of the board feel about that?
It wouldn't, it wouldn't matter to me either way.
Or Ed, do you want to chime in?
I don't have a problem with who the escrow agent is. Very often towns need the money for design, though, because that's the step. If you're looking for public funds, you need to take the initiative to submit an application. And it's called, I think, design estimating, design specification and estimating. And very often that's the seed money that enables a town to get more money to fund the actual improvements. So I think you should include, you should not delete design there. I understand the developer, because the developer would like to pay for actual improvements that will benefit the project. I think in terms of an investment, using that money for design might be a better alternative. And might be more realistic, or would be the seed money to
I've
get the
already
town.
spent 10,000 for design and for the traffic study and some preliminary design already. So it isn't like I haven't spent money.
Yeah, but this is Bill, to be perfectly candid, this is a big project. It's 180 units, plus your 137 townhouse units. This is not a big number. Other developers have made significant mitigation payments here in the town of Southborough. So I don't think 25,000 is an unreasonable
I
number.
just want it to go towards the improvements, so it doesn't get all blown in design, and then there's no money to do the improvements.
Well, I think
I think the way you get the money to do the
I think
improvements.
Ed's point is that, it's like the cart before the horse. It's, if the town has to do some type of design and feasibility study as to what the best course of action would be to do it, and it would be a lot easier to allocate those funds if they had them accessible. So, and for a project this size, I think it's pretty reasonable.
Like I said,
So
whatever, I'd rather put it towards the
Yes.
work so I know it gets
Mr.
done.
I have a comment,
Go ahead.
and my comment is completely against this. I think that it should be negotiated with the Board of Selectmen. They're the one that are doing it, they're responsible for it, we're not at all. And let the developer work it out with them in the way they want it done.
Well, I think they would still work it out with them. We're just,
Let them work it out with them. and
requesting escrow
Completely
for it.
review this out of our condition. We can just
Well-
make a recommendation that it goes to the Board of Selectmen to be discussed.
Any comment from a selectman?
Well, go ahead.
This is an interesting issue, but, and Ed's on point on some of this. It's an interesting offer. I believe you should have it as a condition in this grant, notwithstanding the substantial authority of the Board of Selectmen subsequently. I think it should be in this grant, because it's a result of this project that money is going to be needed for design and/or improvements. Relative to who's holding it, I have the highest respect for Attorney Catanzaro, but historically, on subdivision control and when funds are put forward, although those are subsequently released after the fact, they're held by the municipality. So I just have a concern about the town treasurer not holding the funds, and secondly, why there is a time limit on it. It's almost like a valid mitigation measure, a cost to the town. I don't know if it's enough money, but if you're going to treat it as such, the key phrase I just heard is it's a substantial project. And the issues of Flag Road and the egress are just starting to be addressed. So,
So your suggestion, I think, is part of mitigation. It's basically,
it's paid and it will
don't
be-
expect it back.
no, but it will be used for, it will be used for the purpose intended.
Right, but there is no
Be
timetable.
earmarked.
Right.
But it will be held by the town, and there's no time limit on its use.
I mean,
I think it would just be a mitigation issue then.
right, I mean, I don't have any, I mean, I think it's a small, I think Ed's point is well taken. I think it's a small price to pay for such a big project. So I think that we're already wasting too much time. $25,000 is a lot of money, but in a project like this, it's peanuts. And I think that we should just move forward and not put, I would like to adopt our town council's recommendation that we don't put a time limit on it, and then we just accept.
Why don't we just call it, the developer would give the town 25 grand and cut through all the baloney
Right.
in the paper here?
That's it, and with the
Right.
idea that it would be used towards,
David.
right, would be used towards traffic mitigation, or traffic silence, what are
I
the,
think we just give it to the Board of Selectmen.
Traffic calming.
traffic calming, thank you.
Okay, so on that then, when, we should put when the $25,000 shall be paid, just so I know when I write it. I would say after the issuance of,
Occupancy, first occupancy permit.
Yeah,
okay.
after the issuance of an occupancy
Of-
for the
Right,
first building.
Okay, fine.
First occupancy
Yes,
permit.
Mr. Morris.
Thank you. Don Morris, Planning Board. I just wanted to go through these. I'm getting a lot of looks over here, so some of these are my comments, some of them are the result of people looking at me. So, under the special conditions, F,
Wait, are you referring to comments from the public that you're just,
no,
you?
no, I'm not.
Okay, because
No.
I'd like, these really should be comments from the planning board, nothing to do with echoing eyes or mouthing of conversation, because I know you've
No,
had
I'm not a
conversations
good
with
lip
people in
reader.
the audience this evening.
No.
and you really should focus on the planning board's issues and comments with regards to this project.
I will,
Okay.
and maybe I misspoke, but
Right.
I'm,
Because
the reason I was
public will
getting,
have time, you know, if anyone has any specific comments, we're gonna have time this evening for them to air it out.
so I'll try to be brief to
Okay,
give
thank
that. With respect to, I know you looked over, and it was the first one about the no right turn under the special conditions. And then the next one down additional signage indicating that such entry, subject to use by the overall site's residents, guests, prospective residents, and other invitees. I think it's been stated pretty clearly by the planning board that these are really not enforceable. Is the first one here, that no right turn, would that be put on private property?
Yes.
Yes.
So that's basically our response to those, that they're really not enforceable. We received an email, I think, yesterday from the police chief indicating that they don't even have the resources to try to enforce those two conditions. The next item on here is the left turn at Flag Road.
So,
We haven't addressed
we haven't,
Right, but I'm trying to include that, so it's an overarching comment from the planning board that basically these special conditions that I've just mentioned are not really enforceable. And as far as the 25,000, again, from our experience of the town holding money and having it released back to the developers, I know that you know, the bonds that the planning board has held over the years, once the board votes to release some or all of that, it's handled very quickly. The impression might be that it takes a long time to get to that point, but it's because things aren't complete and the bond therefore shouldn't be released.
Excuse me,
the
Mr.
amount-
Morris, that's been changed.
We agreed to
They're
make it.
giving us $25,000 to keep no matter what. It's not gonna be given back to them at all.
Thank you. The amount, though, I believe that Madison Place provided 350,000. So it's just reinforcing that the 25,000 is really a very insignificant number and nowhere near adequate for the, you know, these SIP pumps, sidewalks, street lighting, and signage, just the construction. And as council said, doesn't even include the design. And then one of the, and then this leads into me leaving and leaving this microphone and allowing the people to talk, because we're almost at the end of this thing. This document, this draft, when was this submitted? What time today was this submitted?
At about 4 o'clock.
2 weeks ago.
The original draft was circulated on August 3rd.
No, the one that
We've
we're
been
reading
working on
from
it
tonight.
for the last 4 or 5 days.
The one that we're reading from tonight is different than the one that we were working with our consultant this afternoon at 1 o'clock. So if this was prepared around 4, that's good. I received my copy at 4:58, and from what I understand, the public does not have this document that we've been talking about for the last several hours. So keeping in mind that you may have either limited questions or questions that may seem you know, inappropriate, but I just wanted to make it clear that I don't think that the public, this document has been made fully available to the public. It's not on any website, is it?
no, but the public should know that it's substantially consistent with what's been released already. There's not a lot that has changed since,
This is getting into public comment, not a
yeah,
planning board issue.
so,
And it wasn't done by us.
It's these conditions that are the heart of what's really changed. The regulatory and the general conditions have been discussed and have been in some form or the other in the draft since the beginning of
Right.
August.
yeah.
It's these conditions that
Yeah.
really haven't been vetted out.
I think I made my point. Thanks.
Thank you. Okay, let's continue on.
I could just add, and the reason these special conditions haven't been vetted out, and I've been working with the applicant's attorney in preparing this draft. This doesn't fall within my sort of role. I mean, I don't decide on these critical sort of special conditions. These are raised for discussion at tonight's meeting. That's the way 40Bs normally work. You have a deliberation session, or ideally, similar to tonight, you discuss proposed conditions prior to the closing of the hearing.
And Mr. Chairman, I think everyone in this room is fully aware that these special conditions, particularly the traffic and safety concerns, have been the subject of hours and hours of discussion, okay, and of professional opinion and review. So this is not new subject matter. This piece of paper may have been printed at 4:53 this afternoon when we finally were able to try to get everything into a piece of paper, but the subject matter is not new, and it would be disingenuous to suggest that it hasn't been fully discussed. So I would like to just go through the rest of these, and then we do have to deal with Flag Road, which we haven't
Go
even
ahead,
written out.
let's move on.
Okay, 4, prior to the issuance of a building permit for the project, the applicant shall deposit, and it's blank, escrow with the town to be available for use by the town to design and construct additional overhead lighting at the John Boland Flag Road intersection. Any such funds remaining in escrow on the date that is 36 months after the applicant has deposited the same into escrow shall be released to the applicant. We were unaware of the necessity of this condition. It appeared, and I don't know whether it was something that the board had wanted or the board sensed that there was a need for.
There's already a light right at the end of the John Boland connector at Flag Road.
Okay.
I don't know whether whoever came up, whoever, wanted this, whether they
I don't
knew
know,
it was there.
was that a
Was this
comment
in
that
the
I made?
engineering? It's not one I did,
Yeah.
but was it in an engineering recommendation?
Might have been, maybe,
It might have been one of yours.
I mentioned it in a previous meeting or something. I honestly don't, the lighting plan has already been part, it's part of the overall,
Right at the
Thing-
intersection.
The
right.
thing is, it's a legal issue. The lighting on Flag Road has to be recommended and controlled by the Board of Selectmen, not us. So that should be completely removed from this condition. And let the Board of Selectmen be responsible for it, that's their job.
Wait, excuse me, you have to use the microphone.
And they didn't write this in here. What? He didn't put this in here.
So I think in our review, we noted that there is a lack of lighting on Flag Road. We did not make any recommendations to add as part of this project to Flag Road because it's an off-site. Our review basically went from the roadway up in terms of the lighting levels
Right.
within the project.
I think in a
So-
previous meeting, we talked about lighting of a sign or some type of signage indicating the name of the project.
Yep, but that's on the plans,
Okay, that's on the plans, and that's,
and it's part of the exhibits.
okay. Okay, so,
Right, and there is uplighting at the sign, right?
Yeah, it's backlit.
Okay, so there's backlit, and then there's a light right at the entrance on the northeast corner.
okay, thank you, Dan.
I have a recommendation that we withdraw it.
Yeah, I think we could strike that.
Strike
Okay.
number 4, or as
I'm calling that 4.
Yeah, I'm just going down.
referred to as 4.
All right.
Number 5, 48 hours' notice shall be given to all affected parties before any water utility disruptions are to occur.
So you're gonna know 48 hours before there's a water main break? Is that,
We have to turn it off, not if
Right.
there's a break.
oh, all right, I got it.
6,
There'd be disruptions due to construction or
Tie-ins to the town.
At times, okay. Yeah, it's a plan break.
Yeah.
6, the project is subject to a certificate or waiver or alternatively, an acceptance of project change issued by the Massachusetts Environmental Policy Act, MEPA. I mean, that's,
Next.
That's something that.
No choice on that. They
We have no
to-
choice. We can't go forward without the MEPA certificate. And now, one that we had discussed earlier that doesn't appear on your sheet, and I don't know whether Ed found another place to put it, but we talked about the Fuss and O'Neill August 24th letter, and I would suggest something in this section about project is subject to compliance to the plans of record changes as recommended by Fuss and O'Neill in correspondence dated 8/24/16, and to changes required by the final order of conditions. That's just suggested language, because I know that we wanted to address that. I don't know if anyone has better language, but I think this is an appropriate place to put that condition.
I agree. I would just add that there's 2 additional letters that we prepared relative to stormwater management that we're still in the process of reviewing with the applicant on May 12th and July 12th, 2016. So the
May 12th, and what else?
July 12th. So there should be reference to 3 letters. The August 24th letter, which dealt mostly with comprehensive permit regulations, and then May 12th and July 12th, which dealt mostly with stormwater and erosion control issues.
So again, that would be the project or the comprehensive permit is subject to compliance to the plan changes, to the plans of record changes as recommended by Fuss and O'Neill in correspondence dated May 12th, July 12th, and August 24th, 2016, and to changes required by final order of conditions by the Conservation Commission or a superseding order of conditions.
There are no issues with the applicants on that?
No, we want to comply with their recommendations and.
Put it in the conditions.
Okay, we can
And
put
it
it
would be
in.
subject to, if these changes are deemed by the board to be substantial, then we would have to be back here. I mean, I don't know, how do we view that, Ed? These,
I think you should put specific language that any such changes shall not require a opening of the public hearing.
if they're consistent with what the consultants are recommending.
I mean, the fact of the matter is, this is a condition of the permit, that you're required to do that, so it's not really a change.
Okay.
That would be a better argument.
Yep.
Dean, you want to add something?
I was just curious as to what level of change would constitute having to come back to the commission? Is there a?
Well, as long as I don't think there would be any requirement to come back to the board if that is a condition of the comprehensive permit.
Yeah, I mean, we don't have a problem with it.
Yeah, okay, so we just
Accept
incorporate
it.
that, that's,
Put it in.
all right, Joe.
What they recommend, we're going to
Okay.
do.
All right, so, let's,
Is that it?
There's one other special condition, but I think we should now go back to the Flag Road issue. There had been comments about no left-hand turn during morning peak hour. Our position is that there should be no prohibition on any left-hand or right-hand turn off of John Boland, but again, we're here to hear what you want.
We're in a situation on this, which I've brought up many times, and I'm going to bring up again, that issue which we talked about at the last meeting on that left-hand turn between 7 and 9, and under a statement that was made by the police chief of whether that's proper or not, I think it ought to be withdrawn and sent to the Board of Selectmen. It's their responsibility. We do not have the right to make that turn left or right. So I think we should just take and drop it and give it to the Board of Selectmen to do.
Okay, Mr. Cipriano?
I have to make some corrections here. First of all, last night, we spoke at length about the jurisdiction of the Board of Selectmen of Public Ways. You keep deferring, Mr. Bartolini, to the Board of Selectmen as it relates to the money aspect. The jurisdiction for mitigation of this project relative to interconnecting ways remains here. The money issue. The jurisdiction on how to expend the money in conjunction with the Board of Selectmen's authority is with the Board of Selectmen. So that has to be addressed here. Whatever mitigation you're going to do, the selectmen can't, there's no jurisdiction for them to mitigate their own public way improvements. But you can do that based upon the impact of the project,
Right.
and then it's left to the
I-
Board
I
of
think the
Selectmen to
question-
decide what to do.
I think Mr. Bartolini is referring to the restriction on the no left turn.
Well, that's the second point. The
Right.
second point is that to me is project-specific, all right? It's egress or access of the project site itself. We discussed that also. There is some jurisdiction to this board to deal with that egress issue, just like you could address enhancements close proximity to the egress of the project to mitigate, I don't know, site issues or safety factors or whatever. Primarily, however, and again, this restates last night, the Board of Selectmen control Flag Road, but you can still address that issue on site if you believe it's an appropriate safety issue to be addressed.
Okay, thank you. I'd like to get a comment from the selectmen on this.
Well, I didn't stand up to comment on that, but I'm a little late coming over with regard to the mitigation number. You know, a couple of meetings ago, I believe Mr. Bartolini, in fairness, misspoke, and Mr. DePietri corrected him about Mr. DePietri being willing to pay for all of the mitigation on Flag Road that is recommended in the DeGray report. I think Mr. DePietri correctly clarified that he's willing to contribute, but he's not willing to pay for it all, and that's fair enough. But I do believe that going from the mistake that he's willing to pay for it all to willing to contribute 25K is a little too precipitous of a drop. And something along the order of magnitude that was done over across the way at Madison Place, I think, is more appropriate. And so I urge you to consider that as you're thinking about that condition.
No, Mr. Serino, I'm going to correct you on that also.
You're going to disagree or
Back
correct, Mr. Bartolini?
2.5 years ago, when Mr. Purple wrote a claim to the Mass Housing of Mr. DePietri, a permit for this, and we had to go through a review and everything. In that decision, Mr. DePietri has it on record that he is not going to give the town of Southborough any mitigation money in lieu of what happened. And we have it in writing in our record, been there for 2.5 years. And that's why there's been no discussion with mitigation money here.
Okay, my comment stands.
We have it in writing.
My comment stands.
Excuse me, quiet, please. Okay, so let's discuss this no left turn. I think it's critical, notwithstanding the police chief's comments about not being able to enforce it. I don't really understand his rationale. I think that a no left turn is a no left turn during certain hours. I think it makes sense. It's certainly not gonna hurt, and I think it would make sense. I think a reasonable person would adhere by those rules, and even our own traffic study and peer-reviewed traffic studies have shown minimal amount of left-hand turns coming out of there anyhow. So I think restricting during the 7 and 9 period, I think makes sense. I really do. And it can't hurt to include it in the order of conditions. Excuse me. So how do you feel, Paul?
To be, I mean, I don't have a strong opinion about that either way. I mean, I understand it was somewhat agreed to at our last session. I do find it very curious, you know, the letter from the police chief, you know, to not do that, you know, due to the fact that it's not enforceable or doesn't have the manpower to enforce it. That perplexes me a little bit, but,
Well, I think during that period in the day, I think there's only a couple officers on patrol, and I think they felt as though they'd be stretched too thin to try to police it. And I get that. But that doesn't mean that a rule's a rule. I mean, there are not cops in every street corner. So I think that by and large, the public adheres to rules, and if it's on if it's a street sign, you know, you don't see people flying through stop signs every day. I mean, people adhere to it, not because they think there's a cop standing there, it's because they think that's the rule of the road.
I mean,
So,
I mean, again, I don't have a problem with the applicant, seem to be okay with it. I just, feel funny going against a recommendation from, from the police department, but, I mean, if it.
And
guess-
I also agreed with what we said last week too about it, but being what the police chief said, I think it should be done differently.
I mean, one alternative would be to condition this on, let's see what happens, a year or 6 months after the occupancy, and to see what's needed. I mean, maybe you're gonna need less or more than this. Again, based on everything we've heard from the professionals and from your own consultants and our consultants, we don't think any limitation is required.
Right.
We don't agree with any limitation, but then again, a reasonable limitation is something that we could live with. The other thing that concerns us is on this no left-hand turn which is primarily during school hours, where school buses are there going to be school buses servicing the residents of Southborough who live in this project and who live in these townhomes 3 and 4 years down the road? Will those school buses be able to turn left onto Flag Road? I mean, I think there's got to be an exception for
right, I
school
would
buses.
assume that we would have to make an exception for a school bus, for sure. I personally think it's better than nothing, and I can't imagine why people would object to it. I think it makes sense, and I think that we should put it in there.
I mean, I don't have a problem with it as long as it's agreeable. I just,
They're already agreeing to it.
if it's agreeable, then I'm fine with it.
They agreeable, I'll go along with it also.
All right, so I'd like to,
So we'll leave it the way it was.
well, I
Condition
mean,
from 7 to
There's
9.
nothing there.
there's nothing
Monday
there, we'd have
through
to
Friday.
create something. I would
So
say,
the condition from 7 to 9, Monday through Friday.
right, no left turn.
What I have written is subject to the applicant installing signs at the intersection of John Boland Road and Flag Road, prohibiting left-hand turns north onto Flag Road between the hours of 7 a.m.
Well, you would have to work with with
DPW,
Karen.
right.
Because you guys don't control that road.
Right.
So you would have to pay for the sign, and Karen would install it, Southborough Public Works would install it and maintain the sign.
Correct.
Okay. So I would say that you would, I would word it that you agree to reimburse the town to install a no left turn between 7 a.m. and 9 a.m., Monday through Friday,
Excluding school buses.
excluding, exactly.
That'd be a big
excluding-
sign then.
Excluding school buses.
I think that you also should exclude police and fire.
Well, I think it's,
Just automatic,
yeah, I don't think you have to worry. Police and fire are gonna blow through anything anyhow if they have to get
that's a given.
somewhere.
let them
Yeah.
do it, yeah.
No one's gonna stop these guys. Okay, Joe, how are we doing? You got,
Well, I have a proposed language for that then.
okay,
Subject to the applicant, and I'll get to installing signs at the inspection, at the intersection of John Boland Road and Flag Road, prohibiting left-hand turns north onto Flag Road between the hours of 7 a.m. and 9 a.m., Monday through Friday, accepting only school buses servicing the overall project, period. Sign location and installation shall be subject to DPW direction with all costs paid by applicant.
And Angelo, except for that first, can you just begin that sentence with the applicant shall?
Okay,
I didn't understand the subject to the job. It
well,
has
because it was a
nothing to do.
condition. The applicant shall install, okay, yep.
one other last order of condition I wanted to address before we move on is trash collection. Because you're gonna control this project, particularly on that 40B side, if we could have some language, some condition in there that restricts the truck from entering and exiting on Flag Road. I see no reason why you would object to that.
No, that's fine.
Okay, so if we could have any refuge truck or garbage truck be prohibited from using John Boland to access Flag. They'd have to enter and exit through.
Physically get down?
Interesting, yeah.
Yeah,
I didn't think of that.
Is that all the conditions?
I think so, yeah.
Yeah, it's not.
There-
No, he's talking about just for the 40B.
Oh,
Just for the 40B.
that's fine.
You
We
can,
have
that could
whatever.
happen.
Yeah, just for the 40B.
What's that?
Yeah, he's talking about we come in Park Central and go straight down to the apartment building.
And
That
then-
works.
But leaving,
Yeah.
when they're full.
Right.
Well, leaving, they're gonna have to go
Yeah.
out and take a right.
They're gonna have to go.
So they're gonna have to go out, but they have to take a right on Flag Road.
They leave, correct.
Even, right. So that's it. That's fine. I
Right.
think, I don't have a problem with that. When they leave the project, they go down John Boland Road, take a right on Flag out to Route 9.
Right.
So no garbage truck would be going down Flag Road north of
Yep.
John Boland. Okay. All right.
Okay. The other conditions which are on here that we need to put down, one which is a major condition for the residents and employees of the town of Southborough, that the residents and town employees get the right of rental on these projects prior to, which is the same thing we did with the
That was already one of the
I think that's-
conditions.
Yeah,
Madison
local
Place
No, that
project.
was
You have
in
the
there
right
with-
to,
For 1 year in the beginning, not for the first time around,
I
but
think
we
it's
put
already,
that in.
it's already in here, isn't it?
Yeah, that was
it's in there.
Yeah, it's in there.
Where?
That was,
Talked about it. You will present a local preference plan to the applicant at the appropriate time.
I
And
asked
the
a
town
question
gets
on
to
it earlier.
choose
Yeah.
the local preferences.
It was at the beginning.
Page
Yeah, but
10.
that's in the thing that we want done now.
Well,
It's
it's
in
in
there.
there. It's
It's
in
in
the order
there.
of
It's
conditions.
pa-
in there.
Page 10, number 14.
Page 10, number 14.
I didn't see it.
Yeah,
What page?
number 14. Right here.
So they will, as part of the final approval, the applicant will need to submit a lottery plan and an affirmative fair housing marketing plan. Part of the lottery plan will include the local preference plan. So the applicant will come to you and say, what do you want? And then it's your burden to submit evidence to DHCD that that plan is consistent with your affirmative fair housing marketing plan. And we've put language in here that, because towns usually don't know how to do that, but the applicant will have an expert who understands lottery plans and affirmative fair housing marketing plans. They're obligated to provide reasonable assistance to you to prepare that documentation.
Oh, can't we just take and use the documentation we did in Madison Place? It's the same thing.
Things change.
I don't think it's legal now.
Things change. You want, the plan for Madison Park, I reviewed that. It's not legal. That had a term of occupancy requirement that you had to be a resident for a number of years. DHCD has deleted that. So we have it the best way. You do it when that lottery plan has to be submitted. Because these laws, the regulations are always changing. So I think we've got it covered more than adequately.
Anything else?
Yeah, the other question is, and I'm personally asking, is on your fish pond that you have, would you consider naming that after someone?
As long as it's not him.
Depends.
The reason is, I have a conservation person that has been on conservation for many, many years, that is getting very old, and that's John Leeds. And I would wonder if you'd consider naming the pond John H. Leeds Jr. Fish Pond.
Sure.
With signage?
What?
With signage?
What's something,
Yeah, I mean,
the board agree first?
I'm fine with that.
Mr. Petrie, do you agree on that?
Fine.
As it was, yep.
I mean, the bunch of the roads are honoring,
exactly, yep.
honoring
Yep, people
members
in
of the
town.
town.
That's why I figured,
Yes.
John Leeds
Right.
had a lot to do with water in the town of Southborough for many, many
Yes,
years.
That's very
So-
nice.
So we put that into, Joe?
I got it.
We got it.
Any other suggestions?
Do you want to, that language I had proposed, one in terms of making sure all consultants are paid. I don't know if you want.
Anyone in particular?
No, we're gonna skip over that one.
That'll be special condition 11.
Right,
Okay.
Special
fight on that.
conditions, yeah.
okay.
Oh, we agree with it, we just won't
Um,
pay you the money.
Any boards want to make a comment before we open this up to the public? Nope, okay. So we're going to allow the public comments now, and we're very interested in hearing what you have to say. We obviously have been to many of these hearings, and we've hosted events, these hearings, and you've expressed your opinions on the project. Many of you have sent letters, both pro and con for this project. Karen's received dozens and dozens of letters from neighbors, both for and against this project. It would be too long and too late into the night if we had to read every one into the public record. They all are part of the public record in the file, so I ask that any person that gets up that would like to read their specific letter into the public record, that you choose not to do that, because I'm not going to allow that. So every letter has been read by the 3 board members here. We're well aware of the concerns. But I think we have in the past done this, and we're going to be consistent. When we get too many letters, it bogs down the process. So I ask that you don't read your letter into the record. It doesn't need to be. It is part of the record. It's available in the building office, and it will stay with the public record. If anyone wants a copy of it, you can get it. So if anyone would like to make a comment. All right.
Hi, thank you. Marnie Houlihan, 26 Clifford Road. So you had mentioned, we also heard in the Board of Selectmen meeting last night, over 40 letters were received last night. We're curious because we don't have a copy of the document you're working with and the track changes. So it's important for us to know you have received, I personally submitted probably 15 or 16 conditions. Would really like to understand, based on the feedback that you heard, what changed in the conditions, the document before you, based on the feedback you got from the citizens specifically?
Well, I mean, a lot of it was, a lot of the comments that were discussed in the letters that you and others submitted to us have been heard and reviewed, and in many cases have been adopted into previous discussions. And so a lot of these conditions are already, talking about, to construction traffic can only take a right turn out of John Boland, hours of construction. There's been a lot of specific requests from citizens that we're trying to adhere to in a reasonable fashion. So, you're suggesting that we're not incorporating anything, and I think that that's not right.
No. I was actually just seeking a track changes version so I could understand what the difference was, because we don't have the after version. We only have the one received and published on the 19th. So I think just for fairness. So that's just one comment. The second comment is specific to the hours of construction. I specifically did ask for incorporation of Massachusetts holidays, which includes things like Patriots' Day, to be included in that, and no work on Sundays. And I think the construction hours were Saturday and Sunday. Saturday, I think it was a shortened time period.
There's no Sunday.
No Sunday.
Sunday.
To include Massachusetts holidays, which would include things like Patriots Holiday
Day too, then?
and Columbus Day.
That's a typical working day.
I would say that there are a few Massachusetts holidays that are really work days. Bunker Hill Day, for instance. There's not too many people have that day off. unless maybe you're a
I
state
don't think that
employee.
was one that I specifically
But
stated.
you know, there are a lot of, you know, obscure state holidays. I think that it's not fair to the process to include those. I think a reasonable person would assume that a normal, you know, federal holidays, no work on Sundays, and certainly no work at night. We've kind of got them narrowed down to the hours of construction. I think it's reasonable for this project. I think that's been covered.
The final comment is I did find an inconsistency with hours of operations on Saturdays. At one point in the document, it stated 3 p.m. At another point in the document, it stated 4:30. I would like the board's clarification for which one you're authorizing.
4:30,
4:30?
and that's how it reads in the document now. Yep.
Okay, so I think it's 4:30.
Okay, just for the record, I'm not comfortable with the Saturday or the hours of operation that this board has agreed to.
Right. Well, you know, keep in mind that for the people that are upset over the Saturday and the hours on Saturday, it's, you know, the longer the project takes. I mean, it's so many construction days to build this project. So if you think of it as a finite number, you have to do it. Are you going to do it over 4 years? You're going to do it over 5 years? So there's a fine line between overdoing it and doing it in a reasonable fashion. I think that being able to operate on part of Saturday, I think that's fair.
John Green, 10 Tower Road. I would rather have the project take longer and remove Saturdays from the working conditions. I think the people and the neighbors deserve Saturday and Sunday to get a break from the noise that's going to happen over a 4-year period. So absolutely, it should be part of the conditions that are in here. There's no reason that you can't give us that. Should be considered. Will you consider changing it?
Well, we can discuss it. I mean, if
It's probably gonna be a lot of things to discuss, so.
yeah, I mean, I've already explained that I don't think there's an issue with doing the Saturdays.
Well, we
I think
do.
it's-
We do, that's the point. And we have to live with it. You don't have to live with it.
It's mandatory, it's done everywhere, everywhere in the state, everywhere in the town.
I don't know, it's,
And prior, so everybody realizes, legally in the town of Southborough, you can do it on Sunday. There is no bylaw to change that.
But we're
15
asking-
years
we're
ago,
asking as part of the
15
conditions,
years
Leo. We don't
ago,
care-
it
the
went to
bylaws
town
obviously don't matter
meeting.
all that much.
It went to town meeting to be done, and it was denied. But
Okay.
we're doing no bylaw, no work on Sunday.
Right, well, thanks for that. Can we consider it? I'd like you guys to consider it because, again, we have to live with the project for 4 to 5 years. There's no timetable for the project. And quite personally, I think that our families deserve the peace and quiet on Saturday and Sunday, as you would if this project was going in your backyard. You absolutely would. You can't tell me that if you're going to have 4 to 5 years construction in your backyard, that you wouldn't like the break on Saturday and Sunday. There's no way you could tell me that. And
Well, typically, you know, I mean, in my world, typically construction sites that work on Saturdays, it's more of a skeleton crew. It's not a full crew because a lot of the workers have already, you know, a lot of companies, for instance, don't want to pay overtime. So what they'll do is they'll limit the Saturday hours.
Well, let's just get rid
And
of it.
therefore, it gives job sites the ability to catch up on some stuff and do some finish work. Usually, it's not a lot of heavy
Okay, well, let's
construction done on.
limit no heavy machinery.
Well, what's your take on this, Bill?
My take is this is a 100-acre site. We're not working directly, we're, you know, affecting 6 direct abutters. And it's only on part of the project. It's not a 2-acre site, we're in everyone's backyard. And there's a buffer between our property line and their backyards. It's basically, you know, 30 or 40 condos that's gonna affect it. The rest of it's far away.
I would not feel comfortable limiting them to what you ask, but I would feel more comfortable suggesting that they do their best to alleviate any type of noise on Saturday.
I don't have an issue with that.
Yeah, doing their best is not, there's nothing legal about doing your best. I mean, there's a lot of things in here that aren't legally binding whatsoever, right? So using language like doing your best in a legal document is ridiculous,
Well,
right?
I mean,
Doing your best, what does that mean? How do you quantify doing your best? I mean, that's like me to tell my kid, do your best. Do your best at school, right? I mean, how do I quantify that?
Well, I'm sure he does his best.
He does
I
his
mean,
best, yeah.
It's, I mean, I
And
think.
is
that-
Bill gonna stand down there and go, do your best, do your best?
Well,
I make a recommendation, we don't do it.
I mean, see,
Leave it the way it is on Saturday with the comment.
Okay, well, we'll add this
okay,
to the.
all right, what's your next comment?
I've got quite a few of them, so,
ahead.
I mean, I'm gonna do my best to go through them as quickly as possible. Let's go to number 8, the notice of.
Excuse me, well, let's keep it professional.
By no means does this mean if I do walk down that I'm not gonna come back. The notice of decision on a use variance approved the site integration of the modified 180 user project within the 158. It goes on to say, and this is number 8 on page 3, the notice of decision incorporated a site concept plan dated April 8, 2015, copy of which is attached here too as Exhibit 2. And I want to note that we don't have copies of any of the exhibits that are in this document. There are none. So we mention attachments and exhibits, and they don't exist in any of the documentation that's been handed out. So let's be clear on that, and we're an hour away from voting on this. The use variance is effective upon and conditioned on granting of this comprehensive permit to the applicant in substantial compliance with the concept plan. Right, so I thought we were eliminating everything 40A in this document, and this clearly states that the use variance is effective upon and conditioned on granting this comprehensive permit to the applicant. Should be stricken, absolutely stricken. We're still waiting for the planning board, we're still waiting for conservation to comment on anything 40A, correct? That's what we were told.
We're here to approve the 40B project.
The 40B project,
Right.
not the 48 project, because we've been pulling townhouse language out of this, and this directly talks about townhouse. Use
We
variance.
approved the 48 project 18 months ago.
Okay,
It's
well,
done and approved.
I thought it was still being reviewed by the planning board. So if you already approved it, then it's not really being reviewed. So it's one or the other, you don't get both.
It's subject to.
Subject to, but subject to what? Subject to review, do you have to comply by the review, or you don't have to
It's
comply by the
subject to
review?
residual site plan review.
So do you have to comply by it or not?
Residual site plan review.
What does that mean?
Yeah,
Exactly.
What page and number?
Number 3, page 3, number 8.
If you feel there's any language in there that refers to a
Notice of decision incorporated a site concept plan dated April 8th, 2015, where it starts. And then it goes on to say the use variance is effective upon and conditioned on granting this comprehensive permit to the applicant in substantial compliance with the concept plan. And what Bill is saying is it's under residual review, but then this document goes on to say that we've already reviewed lighting, landscaping, and everything else that is part of the residual review, so why are we putting up this facade that there's actually a review going on after this? There's no review going on after this.
Well, let me
That's
address
not what this
this. That
document
first
says.
section, if you take a look at the title, and there are different sections in a comprehensive permit decision, this is the procedural history. And page 3, I think is simply a recital of the history of the project, no
Yep,
more, no
but
less.
It says the variant effective upon and conditioned on granting this comprehensive permit. Isn't that what we're doing tonight? We're granting the comprehensive permit?
But isn't that just a statement of fact?
No.
Well,
It's what we're doing.
Isn't
But-
that
But
what-
then you
That's
go,
the-
but then you go on
process
to,
we're
That
doing.
was the history of the
but
project.
then you go on to say that we're still reviewing the 48 project through the planning board, which we're not doing. Because if we grant the use variance right here, this basically null and voids everything else you say in the rest of this that would give any teeth to the 48 review. You pull it out. You pull it out.
You can't pull it out. It's in there.
Well,
It's not part of the decision.
It's the history.
It's not part of the decision. He's just stating what happened over the last 30 months.
Yeah, that's
That's all that, that
Yeah,
entire
that's a
section.
summary of the history
So
of
we're
it.
following the entire use variance upon approval of this
It's still
comprehensive plan.
subject, the conditions, and I'll defer to the applicant's attorney, there are conditions in the use variance which grant certain review, rights to the planning board on certain matters related to the 40A development.
4 areas,
This
right?
doesn't.
4 areas,
Right.
lighting, landscape, what were the other ones, parking and
Sidewalks.
sidewalks, which then it goes on later on to say that that's already been done.
For the project is a defined term.
What is the
The
project?
project is 180 units of rental housing,
Okay.
25% of which shall be affordable.
So the use variance doesn't come into effect at all in here, so why don't we just strike 8 altogether? So if they.
Because it's a
'cause
history.
well, the use
It's a-
variance, but
It's
the
not-
use
it's-
variance has
it's a-
nothing to do with
It's a
this.
statement of fact, it's the history of the project.
I don't agree with
So I'm not really sure, what you're saying is, let's rewrite the history.
No, what I'm saying is
That's-
that this
this
has
is-
no
this-
relation, this has no relation whatsoever
But it's just,
to what
it's
we're
just
approving
for
tonight.
historical purposes,
No,
that's all it is.
Then if it's just for historical purposes, we don't need it.
Mr. Chairman, it's part of what occurred during the 40B comprehensive permit application process.
Right.
When we first started this, there was no use variance. As part of the hearings on this comprehensive permit, there was a delay in the proceedings because there was a negotiated agreement with neighbors that resulted in a use variance. These proceedings were stayed for several months while that took place. It is an appropriate part of the history of these proceedings, and I think it's important that it's
There's
in
a
the
reason he wants
decision
it in here so
so that any reviewing court, okay, or board sees what the history is. That's our position.
Yeah, I don't have any problem with keeping it in there, it's a fact.
It's a fact though, but then you go on to say that we have all of these different.
No, I know, but,
different,
okay, you made your
areas of
point.
the
Why don't you
planning
go to
board.
the next, why don't you go to your
I'm
next?
sure, we'll just sweep that one. Okay. The next, number 9, last sentence, through the agreement and declaration of restricted covenants, the neighborhood property owners agreed not to object to the project and the townhome condominium proposal as modified, right? I'm a neighbor. I'm a property owner. I can certainly, object to the project.
Absolutely.
So why does it say in there that I can't?
I think it was the ones that were part of the agreement they're referring to.
The abutters,
Again, shouldn't be in there.
abutters.
It says that,
Talking-
Mr.
you're
Gr- it
talking
says
about-
it through the agreement.
The whole agreement shouldn't be in here. We're talking about the 40B. We're not talking about the 40A. The use variance gives you the ability to build the townhouses, which is 40A. It's not 40B.
Mr. Chairman, it's our position, again, it's part of the history of the proceedings, and we think it's appropriate to be in there for the same reasons that I stated before. It's a
Mr. Marchand,
recorded document.
I
And-
agree.
So you're saying that the 40, so
I
the whole time you
agree.
sit up here, you say the 40B is the 40B and it's not the 40A. But yet we have language in here that's related to the 40A and the 40B.
But that section is the procedural history of the project. The negotiations with the neighbors, and I played a minor role as a mediator in that,
Great job.
was important. In fact, the suggestion to move the higher density, taller buildings away from the neighborhood was suggested first by a staff person in the planning department here. The neighborhood said we would prefer to have lower scale buildings adjacent to the neighborhood.
And even in the
That was
DER.
good planning.
No, that's not good planning because you gave us bad advice because there's no way 5-story buildings were going in there to begin with.
Yes,
No
they
way, because
were.
even in the
Yes.
DEIR, it says no buildings over 3 stories. It says no buildings over 3 stories, so you did
Okay,
give us
why don't
bad-
you move to your next point?
Okay, let's keep going.
Right.
They were 4-story buildings.
Yeah, they were 4-story buildings, but if you look at the DEIR, it's telling you that you shouldn't go over 3 stories because it doesn't meet the character of the neighborhood. And the other 40B consultant said that there was absolutely no way there were gonna be 500 units going in there, so again, Mr. Marchant, you gave us poor advice.
That is incorrect.
Okay, page 6,
Just let-
number
just let him
16.
move
Exhibit 4, I'd like to know where the exhibit is. There's no exhibit.
Exhibit 4 has been circulated with the agreement, and it should be on the town website.
So I should just know what Exhibit 4 is? and
I
where
don't,
it
I don't know
lives.
what you should know, Mr. Green. All I'm saying is that the exhibits
Well, I'm just saying,
were
I mean,
submitted.
this is a
Well,
professional environment. If you're going to,
Under-
reference something in a document, shouldn't you have Exhibit 4 ready?
It's ready.
Then where is it?
It was submitted to the town. I don't know why it's
The
not on
notice
the
of
town.
decision.
What's that?
Isn't it the notice of decision?
No, there are 4 exhibits. There are exhibits here.
Then
The
why,
exhibits
then
have been
why are they not part
circulated?
of this package? You guys are gonna vote on this in an hour. You've got a ton of people out here that wanna know what's going on, and we have no idea. Nobody has any idea. And you guys are rushing through to make a decision, because for one reason or another, you don't want us to have all the information. Okay, let's move on. The public hearing, number 18, page 6. The public hearing was closed on August 24th, 2016. How is the public hearing already closed?
Anticipating that it's going to close tonight, because we're not going to extend it.
This is part of a
August
draft.
31st.
You understand?
I understand, but it's probably
Okay.
an
All right.
inappropriate thing to put on there.
Okay.
And also, Mr. Green, for your information, Exhibit 4 was the minutes of the meeting which are public record.
The minutes of what meeting?
The minutes of the meetings of the zoning board of appeal.
Okay, then why wasn't that included
They
as part of
were
the package?
included. I can't explain why you don't have them, but they were included.
They're part of the
And then we
public
go to-
record.
So where's Exhibit 2? You mentioned
Same
Exhibit
thing.
2.
All the exhibits are right here.
Exhibit 6, Exhibit 5, Exhibit 3.
All right, and do you have anything else?
Yeah.
Before, because we have a lot of
yeah.
people that
Well,
want
I'm sure, but,
Okay.
I mean, we can be here till 1 o'clock in the morning, it's okay.
No, we can't.
to. Well, no, that's not the case.
Well.
So we're gonna
I'm
move this meeting along,
Okay.
because if you're
Well,
just gonna
I'm gonna say my
filibuster all.
piece before you close this public hearing, there's no doubt. So the overall site consists of approximately 100 acres. The project site is situated on 9.03. Project consists of rental housing apartment component. So something I really want clarification on is if we are talking about just the 40B aspect in the rentals tonight, where is that line drawn in the sand on the project as to what we're agreeing to as far as exterior? Right? So we're agreeing to exterior landscaping, we're agreeing to exterior lighting, we're setting dimensions for roadways. So where does that start and stop?
Well, I think some of the lighting, street lighting, is common to both parts, right? So we already talked about that in previous meetings.
Many meetings.
The street lighting is on the plans.
Yeah, it's in-
Everything should be.
It's on the
So
plans.
everything outside, so the
Plans of
whole
record.
site, even though we're
Yeah.
not talking about townhouses.
Right.
We're basically approving all of the
Because,
side
because we
roads.
already, right, because we already, at previous meetings, which I'm sure you were at,
I
we
am.
talked about the roads
No,
and
but
all
we-
the feeder roads and all the roads that.
Right. But what you're putting in here is trying to make it sound like we're only talking about the rental properties. We're not talking about townhouses. Yet you are approving all the roadways, all the landscaping, and everything around the townhouses. So, again, what are we actually
No,
reviewing through the
No, we're
planning
not.
board?
No, we're
No,
not. No, we're
you're
not.
wrong in what
We're
you're
not.
saying, Mr. Green. We're reviewing the main roadways and everything. The planning board is taking care of the lighting on the use variance property and all that stuff that, we sent that to them, that's something they're gonna take care of. What we approved on the lighting is in all the main roadways. That's what
Okay.
we approved.
Okay, so is the planning board actually going to have any teeth in this matter whatsoever? Right? Outside of those 4 areas that we've talked about. So when we're regarding the 40A project and the density of the project, the landscape, the buffer or lack thereof, the clear cutting all the way up to the property lines on Terra Road, obviously, we don't even have a say in hours of operation or any of those things. Are they gonna have any input whatsoever, or are we just going through this for no reason?
They're continuing the hearings, and they're gonna give the developer feedback on what they want.
But does he have to adhere to it? Again, do we adhere to it or we don't have to adhere to it?
Well, I think the developer has made a good faith effort to work with the planning board and to try to resolve some of the
How
issues
can you
that they.
say that?
Well,
How can you say that? They just
Excuse
got,
me,
they just
if you
got the
don't
plan.
let me talk and you want to talk over me, then we're not going to get anything done.
Okay.
Okay? You've had the floor for now 20 minutes.
Okay, well, I've
So,
I've
and
still
there's a
got
lot of
another-
people that want to speak, and you're rehashing, by the way, many things that you've rehashed in many meetings before.
This is all
I
of
know,
your-
and you're suggesting that this is the first time you've seen this stuff.
It is.
And I'm telling you that a lot of the stuff coming out of your mouth is stuff that you've regurgitated numerous times to us. So
And
we're
you- and you
very
haven't done anything
familiar
about it.
with the points that you're trying to make. So
Does anybody have a problem with me speaking?
excuse me, ma'am, I'm gonna ask you to leave because you weren't asked to speak, okay? When it's your turn, you can go up there and speak, but we can't have people talking out of turn. We're trying to keep this civil, please, okay? So, you've had the floor. If you have specific questions.
I do.
I've
I've got a ton
I've
of
told you that the planning board is working with the developer on the 40A side.
Yep.
And
This is very muddy, Mr. Eagle, very muddy, right? So we don't understand where the 40A starts and the 40A begins. So these questions are extremely valid when you're talking about an order of conditions. We have no idea where it starts and
The thing is
stops.
wrong, Mr. Green, on this here. Mr. Cipriano has gone to the concept planning board meetings, and it's been discussed. It's been discussed at the selectmen's meeting on the process of everything that's being done.
I'm not sure. the planning
Everybody's
board would
been
agree with you.
told, and you've been at all those meetings and been listened, and have been told what was done and how it was being done.
Okay,
So there
I-
is no reason to discuss it now.
Yeah, of course not. Why would we possibly want to address any of
Excuse
the
me.
citizens' issues? Okay, I'm not sure the planning board would even agree with you. Okay, so regulatory conditions, 180 rental units, no mention of the townhouses. I swear I'll get through this. Exhibit 4, Grand Always so forth. You only gave me 5 minutes to look at this, so.
Sitting here for 3
Plans of
hours.
record. Grants all waivers set forth in Exhibit 4 to the extent any other waivers of the requirements of local laws or other local rules or regulations are required to construct a project is shown on the plans of the record. Those waivers are also hereby granted. Applicants shall comply with all provisions of the general bylaws, zoning bylaws, and all the rules and regulations applicable thereto. Is that on the 40A or the 40B, or how does that work? If somebody could clarify that for me, I don't know what it means.
that's the 40B.
The 40B, so it has nothing to do with the townhouses. Number 2, page 12, comprehensive permit plans pursuant to notice of a decision on a use variance. Again, we're mentioning the 48 section. All infrastructure shown on the plans of record is serving the project. All roadways, parking areas, emergency access, stormwater management facilities, snow plowing, landscaping, trash and recycling, street lighting. Is this just the 40B townhouse, 40B rentals, or does it include the 40A?
Oh, which one are we talking about?
This is 12, number 4, A through I.
40B.
That's just the
40B only? Okay,
Yes.
so we're still gonna go through this as part of the 40A.
Correct.
Or we're
You're
not?
gonna meet with the planning board with regards to the 40A, absolutely.
Can we get that in writing? 19, same thing, 40A or 40B. Lighting plan, landscape, snow removal. We'd like to have, I mean, I'd love to have it in writing that outlines.
That was
where-
deleted, Mr. Green.
Okay, thank you. It's not easy. I mean, you did give us 15
Excuse me,
minutes.
no sarcasm.
I'd like to add to 18, number 9, blasting, if any, shall be performed in accordance with applicable law. I'd like to include no stone or boulder grinding, crushing on site. It's extremely loud. There's machines that crush boulders into small pieces of stone, and it's extremely loud. I think that should be,
Well, I think
Included as part
we
of that.
we discussed they'd have to adhere to certain state
There are
requirements.
existing state requirements in terms of decibel levels related to those construction practices. The applicant will be required to comply with that.
how is that controlled?
There is no control on it. If I'm gonna straighten out because I live on Oak Hill Road.
Yeah.
And when they built this summer on the childcare on Route 9.
Yep.
And they broke all the ledge with hammers.
Right.
And they did it 24 hours a day, 7 days a week.
Right.
And it kept the whole town awake.
It's a problem,
But they were allowed to do it.
Okay, but it's a problem. I mean, if you agree it's a problem, Mr. Bartolini, why can't you help us?
We have to
Right.
put up with it.
We just have to put up with it. We don't have to put up with anything. That's where you're wrong, right? I mean, you keep saying this, that we have to put up with it, we have to put up with it. No, this is why we have this process. We don't have to
The
put up.
thing is, we've regulated the hours to do it in. But it's a construction, they have to do it. It has to be
Right,
maintained.
it's not a quarry,
And the
so.
state regulates it.
Yeah. So
It's a 3 to 4 year project.
It's regulated, there are provisions. If you feel the contractor is in violation of the requirements, you're gonna, I'm sure, Mr. Green, you will make a call.
Oh, I'll make calls. It's just a matter of whether or not they get answered is the problem, right? That's the issue.
The zoning enforcement officer is responsible for enforcing those rules.
Okay, so what's the lead time on him getting back to me if I'm to call?
excuse me, it's not, I'm
It's
asking you to try to keep it
It's a serious
professional.
question.
All right, what else you got?
Construction trucks on Flag Road, right? So you mentioned he has to come in Flag Road to start the project. I get that. I think there should be some limitation around the length of time that takes. What really concerns me is construction vehicles heading from the north down Flag Road to get to the project site itself.
They're not gonna be allowed.
They're not allowed.
They're
From
not
the
allowed.
north.
From the north,
So
they're not
from
allowed.
Route 30, they cannot
Not
come
allowed.
down. Okay, so if we
Made
see,
that a condition
Right,
already.
not allowed.
okay, all right, just making sure.
Yep.
Let's see here. Piling of dirt, I'd request that there's some sort of limitation on the height of the dirt. It's actually, it's an extreme danger for little kids if they do get on the site. If they can
Shouldn't be
actually
on the
sink into
Well,
it.
why would little
Why
kids
are
be
little
on the
kids on
site?
the
Because they might get in there, they live in the neighborhood.
Well, if there's
If you know
construction
little kids-
vehicles on the site, it's.
Yeah,
an
we
extra- I
can't
mean,
control that.
just
That's,
telling you.
Private property.
right, you control your own children.
Okay, liability. Project during the next 365 days, so materials for 365 days, I'd recommend that that's brought down to at least 180. There shouldn't be piles of material laying on a construction site for a year.
Well, that's part of the construction process.
And the Board of Selectmen permitted it over a year and 2 years ago to put material on that site.
So does that matter?
The essence
It's
of
there.
that is
They
there's
have a
no
permit
excessive
to do it.
stockpiling on the property.
During the period of construction of the project, the applicant will ensure that no construction activity occurs on any abutting property outside of the overall site. I'd recommend a buffer zone of 75 feet, and fences added from there, physical barrier, that there is absolutely a no cut zone. There is a no activity or storing of material or trailers, any of those things that are happening within a buffer zone to the abutters.
Is that something that's reasonable?
Well, I mean,
The,
fencing,
no trailer within a buffer zone is reasonable.
yeah,
Yeah, so if
okay.
there,
And that's in the,
That's already in there.
the conditions.
No, it said that you could have 2 trailers on the site, didn't say anything,
Yes, it
it
did
said
with
buffers
that.
to wetlands.
No,
It's
it's
within setbacks.
Yeah, that's part of it, right,
it's already in there.
part of the building code.
As part of the water flow, after the water has been set, the water pressure to be retested to make sure the PSI has not been lowered within the neighborhood. Pear says it's not going to, but I feel like it should be retested. And if for any reason that the Park Central development has been detrimental to the PSI, that the developer be responsible for mitigation.
Well, we've already had them look into it, and that, we're going based on their opinion.
And the
their-
comments from Ms. Gallagher.
Right, but I,
So I would say that it's a moot point. We've got an engineer that's already reviewed it, plus our own town, Karen has reviewed it, and they don't see a problem.
okay, I guess you don't
Like,
see
we
any
can't, we can't anticipate a problem when professionals feel as though there won't be a problem.
I'm just asking it's retested after
Okay.
it happens, right? It should be retested after it happens to
It-
make
it-
sure it hasn't been
It
detrimental.
shouldn't be a
We
part
have
of the
this
order of
already.
conditions.
Again, I know we're just rolling through this. Controlled construction, can you define what controlled construction means? Is there gonna be somebody on the site at all points in time to make sure that the construction is done in a professional manner?
There'll be, I'm sure there'll be a
There
construction
already is
manager.
a defined word under the Massachusetts
Yeah.
State Building Code.
Okay, what about certification of dirt and where it's coming from? Make sure it doesn't have any hazardous materials?
We're not hauling any dirt in other than sand and gravel and
Right.
stone for laying pipe.
Okay.
It's not a fill
Can we
site.
put that in there, if he's in agreement
What,
with it?
what would you want me to put in there?
I don't want to see any loom coming from other sites that
I think they'll be removing
may have
loom, probably.
hazardous material in it. It's been known to happen.
I mean, dumping is
Connector roof.
illegal, so.
Right, I
Well,
mean,
dumping is illegal, but a lot of
You-
times developers will take dirt from one site to another without ever having it tested, and
Right,
it ends
but
up on a new site.
I can't put an order of condition that says, if you do this illegally, you're in trouble. I mean, that's really what you're saying. It's already illegal to do it. I don't have to put it in the
Happens all the
conditions.
time.
General,
The other
just
thing is,
nothing
that's
illegal?
a mandatory permit by the Board of Selectmen also, nothing to do with us.
Right, the Fuss and O'Neill, page 7, says per section 6.9, the applicant is encouraged to retain a minimum 50% of the site as permanent open space. So my question is, right now, what percentage of the site is open space?
Wait, you have to use the microphone and you have to identify yourself.
Wayne Bellick, Waterman Design. By definition of the zoning bylaw, open space is defined as any area not covered by buildings, roads, parking areas, and wetlands. So based on that, more than 50% of the site is open space, which we will reflect on the site plans as well.
Thank you. Is that it?
No. Sand and salt. I'd suggest in F, special conditions, to put not a through street. I realize it is a through street, but no right turn, it's probably not as effective.
Wait, I'm not sure.
Applicant shall install no right turn directional signs at the exit from both the Red Roof Inn, Cumberland Farms. I think a lot of people that visit Cumberland Farms don't necessarily know that it would be a through street, so if you put not a through street, I think they'd be even less likely to go down there, because they know they'd have to turn around and come back.
Oh, add a sign that says no through street
Yes.
next to the sign that says no right turn?
No problem.
Okay.
I got
Well,
something, look at that.
You got
Holy
something.
cow. How did that happen? Merry Christmas,
Good
no
point.
through street.
Point well taken.
Yeah, unbelievable.
Okay. We'll add that in there, Joe? Okay.
Construction timeframes, again, I've got it written here, Monday through Friday only, that would be very much appreciated. All right, okay, the special conditions now. Land areas in previous plans stated as connection to Tara Bantry Road to be deeded, the original plan had, and this was part of the use variance, I want to make sure that it goes into the order of conditions, because there might be some things that hold that up. Land areas in previous plans stated connection to Tara, Bantry Road, those should be deeded as open space in perpetuity. Emergency access at Blackthorn also should be accepted as emergency only in perpetuity, so that that can't be changed by the town at any point in time.
The agreement's been recorded, it's at the Registry of Deeds, it's
already-
in perpetuity.
It's part of the record, it's in,
Yep.
Registry of Deeds has it.
Still
It's-
part of the 40A, so that's part of the use variance, so that's supposedly different than this.
It's done by both, by the police and fire.
Correct? Additionally, so this is going to the left-hand turn. So you guys had said something about a sign, which seemed like it was a little bit preset to me, but additionally, developer agrees that any changes made by citizen petition or BOS are acceptable regarding restrictions to Flag Road northbound. I think that should be added. I don't think.
Wait, say that again?
In addition to the sign that says no turn between 7 and 9.
Yep.
I think it should say additionally, the developer agrees that any changes made by citizens petition or Board of Selectmen are acceptable regarding restrictions to Flag Road northbound.
No.
I don't think so.
No.
Why not? You said you
No.
were fine with any of the changes?
No,
or
no.
left turn onto
No.
Flag Road?
No, no, that's not gonna,
Why is
that's
that,
not gonna fly,
Mr. Eagle?
because,
Why are you so quick to defend his position? I don't
because it's
understand.
not a reasonable thing to put in there, that's why. Because this
It
is a
isn't.
project, no, it's not a
We have
reasonable.
huge safety problems on Flag Road.
Well,
You don't
it's,
see
all right,
it that way.
we've already discussed the issue with Flag Road. We've had experts from,
And this is
from,
obvious where
from
this
two
is
different
going.
sides looking at it.
All right,
So,
I'm trying
We've
to
already
keep us out of court
incorporated
here.
what we think is sufficient.
I'm trying to keep us out of court. 25K is not enough. I think it should be, closer to the 250K. Any detrimental effects to PSI I already went over. Previous discussion on mitigation at the beginning of project, that the original project had quite a substantial amount of mitigation money. Then, for one reason or another, Mr. DePietri didn't get his way, said he was gonna pull it. That was in public. I'm not sure what that amount was. Do we remember, Mr. DePietri?
There was no
There
amount.
was no amount.
There was no amount, and
There was.
mitigation is
No,
not.
there wasn't.
There was. It's in the
Well,
newspaper with
you-
him commenting on it.
Okay.
So what's the amount?
What is the amount then?
I have to pull it up for you. I just remembered it as we were talking about
But
mitigation.
you remember there was a number, but you don't know the number.
Yeah, I do.
Okay.
Is that all right? Okay. That these final changes should be reviewed by the public for at least 24 hours to make additional comments. There's no way a vote should happen tonight. We haven't had the appropriate information. We haven't had the time to actually go through this in an appropriate manner. I'm sure you're going to deny that too. Trash truck restrictions to add no trash collection sites within 100 feet of a butter property, so not just the trash trucks, but there shouldn't be trash collection sites. There should be a 72-hour notice of water utility, and a limitation of a 2-hour disruption.
No.
A
So you're gonna put us
limitation-
out of water for how long? Like just an unlimited amount of time? Or are we gonna put some sort of parameter around that?
Mr. Chairman, when we go to do the water shutdown, the town tells us when we can start and when we can stop.
Right, it's
It's
not,
not a big deal, I
it's
know.
not
Okay,
unusual.
all right, thank you. We know it's,
Thank you.
all of this is
Tha-
not a big deal to you guys. Thanks.
You know, sir, we're trying to keep this a little bit more professional, and, sir, I'm gonna have to ask you to leave if you continue, all right, thank you.
That's the office to remove.
Could you please remove him from the room, please?
Sir?
Thank you. Okay, next.
Deep breath. Everyone take a big deep breath.
Bring it back to earth, Janet,
Well,
please.
I don't know. We'll see. Janet Sussman, One Flag Road, Southborough. I would just like to comment, I understand there's some discrepancy in opinion with regard to receiving the document that you're all working from, date, time stamped around 4 o'clock today, which the planning board also received. I think I'm just looking at it as past times I've shown up at meetings, there seems just to be some communication issues, so I think tonight it would have been very helpful if packets of this document were left for all of us to follow along as Attorney Catanzano read through every line item. And if we couldn't have the packets, it could have been posted up on the screen. I don't know, I've not been to any 40B hearings. This is my first, so I don't know if this is a common practice or not. But whether it's common practice or not, I think it would have been extremely helpful if we were all able to follow along with the conditions. I understand you said that there have not been that many changes, but things are being rewritten. It was very, very difficult to follow along tonight, and as you were sitting in here to prepare your comments on a document that did not coincide with a document from the attorney, Mr. Marchant, and this entire board. So that is something I'd like to just state for the record, if this ever happens again. Could there please be information packets for everyone who's been invited to the public hearing?
I'd like to make a comment.
Sure, Mr. Bartolini.
The comment is that on other 40B projects and other approvals by this board, this discussion has never been done publicly before. We normally close public hearings and we discuss our decisions and everything because we wanted to do it with the public and give the public the opportunity to look at it, to, be involved and answer any questions. That's never been done before in a decision. So we're doing it in favor of the residents.
Of course.
Yes, Mr. Cipriano.
Mr. Bartolini, the advice of town council in the past is that the conditions are discussed in public session. I remember when your board did not do that, and I advised you against it. So the rule of procedure has been, for the last several years that I've been involved, that those conditions are discussed in public session. That's the
Right.
only
That's what we're
appropriate way
doing.
to do it, not go into an executive session, not executive, but
could
go
I-
into a deliberative session.
Could I get a
Public
third
meeting.
explanation? Very often, boards will close the hearing prior to a discussion of the conditions. They will then schedule a deliberation session, which is a public meeting, but not a public hearing.
And
Which
that's
does
what we've
not
done.
give the public the right to participate, as opposed to a public hearing, which is tonight's meeting, where the public has a right to participate.
And I agree.
You do
that-
not, discussion of conditions is not a suitable topic for executive session.
No, it is not. But the point is that there is that procedure, but my advice to my clients is that those conditions be discussed, walk through with the public at large in a public hearing. Then the public hearing closes, the board goes into deliberative session and works out the conditions.
And I agree with that.
All right.
Right,
Is that
and I
as we're
agree,
doing?
and I agree with the process. I mean, Janet, to answer your question, there was a draft circulated about a week ago. Okay. And again, I'm gonna state this again, there's really not much has changed. There's a few tweaks to it. And any of those tweaks were hashed out well in advance before the public had a chance to comment. And we purposely wanted people in the public to wait until the end to make their comments, so they would have time to hear through everything and make their notes and figure what they wanted to say when they had the ability to say it. We're trying to be as transparent as we can.
I would just like to clarify for the record, I'm not accusing anyone, I'm just making a suggestion that it would have been easier for all of us in the room tonight. That's my suggestion.
Okay.
Please understand, I am not accusing this board.
I accept your suggestion.
I am just making a suggestion going forward.
Right.
It would have been easier for all of us
Absolutely.
who would like to come to the podium and comment on the conditions.
Right.
To have had the most updated packet of information.
Right.
To follow the discussion.
Right.
Thank you.
And-
But I'll let Mr. Stivers.
Mr. Chairman, if I may just say
Yes.
one brief comment. The writing and the final preparation of a decision by a zoning board is not necessarily something that the public has to participate in. In fact, I've been before, and I'm sure other attorneys in this room have been before, dozens and dozens of zoning boards throughout the Commonwealth in which the zoning board writes the decision. As an accommodation to this board, because this is such a lengthy process, okay, we did an initial draft of the decision. This board has, circulating a decision prior to the board writing it was an accommodation to the public, just as
Absolutely.
Mr. Bartolini and you suggested. There's no requirement that the public participate in writing every sentence in a decision. Now, I also agree with Attorney Cipriano that discussing the conditions, okay, publicly, in this instance, is a good idea, and that's what I think that we were doing tonight, and we have done in the past.
Right.
Because we've talked about the concerns of the public for several meetings. So I just wanted to clarify that there is no requirement that the public participate in the actual writing of the decision. I think this board has gone a long way in being transparent.
Yeah, and contrary to what some of the public feels, I mean, a lot of the comments that the public have made to us, we've tried to incorporate, we've tried to negotiate with the developer. So I don't want you to think that, I don't want people to feel as though that this is a one-way street. You know, we're limited to some degree as to what we can get from a developer when they propose a 40B project. So we're trying to get as much as we can. We're trying to look out for the best interests of our neighbors. And so I don't want you to think that there's an adversarial situation here. We've taken your comments, and many of them have been incorporated in tonight's, work. So we thank you for your input. Mr. Stivers.
Sam Stivers, 7 Presidential Drive, a member of the advisory committee, but speaking as an individual citizen, former member and chairman of the ZBA. A point of fact, I want to correct Mr. Bartolini's error. In fact, it has been a practice to discuss conditions in public hearings. Mr. Bartolini and I sat on ZBA for Woodland Meadows project interminably, Stonebrook Village interminably, and we talked at great length with residents about conditions as part of that process before the public hearing was closed, and it was a very productive process in both cases and consistent with the town council's advice. That's why we did that, and we felt that it was an important part of the process to hear the public about conditions. And so, in fact, that is a history in Southborough to do that. Thank you.
Thank you. Yes, Mrs. Sussman.
Okay, with regard to the Saturday workday, would it all be possible not to have blasting or drilling on a Saturday?
Yes, no problem.
There you go.
Thank you, Mr. DePietri.
Why don't
Can
we
we
add that
write
in
that
there?
into the conditions, please?
Absolutely. Thank you.
Thank you. one other question. We talked about construction vehicles not entering through Flag Road. I'd like to also include project employees. Is that at all
Well,
possible?
construction,
Well, I mean, construction to me was implying more
Excuse
heavy.
me, ma'am. Nobody's gonna be able to go in the road. It's gonna be blocked off.
well, no,
So
they're
they're
talking
all
about
gonna
coming
have
from
to
the
go
north.
through Park Central
No, no.
Drive.
They're talking about people that live, let's say, in Marlboro, that could go down Flag Road and then take a right on John Bolton to go to work.
No,
Is that what
John
you're talking-
Boland Road is going to be blocked off.
Down Flag Road, you mean?
Down Flag Road to take a right on John Bolton.
No, down Flag Road to Route 9.
Route 9.
Down, right, exactly.
Okay, I just wanted to make sure that, if possible, the conditions included that in Mr. DePietri's employees on the project, not necessarily an outsider of a construction company that's hired to bring fill or to haul heavy
Okay.
equipment.
So- all
Well,
right,
we
so-
can go one step further there, is we can add to a condition that Mr. Petrie notify employees that they have to enter through Park Central off of Route 9 and not use Flag Road.
Right,
Do
not
you
use
agree to do that?
I agree.
Basically,
So
not
we'll
use
make
Flag
that a
Road at all.
decision, all right?
Thank you,
Yeah.
everyone. I'd like that to be written into the
Yep, so
conditions.
We'll
not
do
use-
that.
Yeah, not use Flag Road at all, and must enter, because we're trying to avoid people going down Flag Road, getting on Route 9, and then curling into the project.
Send a letter
So,
to-
so if we just say,
employees.
no employees are allowed to use Flag Road to enter the site, and they must enter from Route 9 into the project from,
During the construction.
during the construction.
During the construction
Right.
period, from the beginning, the first day, to the very
the
last
end.
day, when you crack your bottle of
Thank you.
champagne and say you did it.
Thank you, Janet. Yes.
Let's see, I'd like to know, I thought it was a little vague as to how neighbors or abutters will be notified when there are days of the drilling or the blasting. We seem to have, how would you suggest that, Mr.
That You
DePietri?
get as a butters, you get very well notified when any blasting
within-
is gonna occur.
I think this may affect more than just the direct
No, no,
abutter.
it's
No.
everyone within 300 feet of the property have to be notified under state law.
Okay, and just out of curiosity, because I don't know the answer to this question, how are you notified?
We actually have to come do a pre-blast survey in your house. We physically have to go into your house to check for cracks, existing cracks and whatnot.
But in terms of being notified the day of the blasting, like
They will let everyone know. They do a robocall.
a robocall? Okay, thank you.
And this recently occurred, I mean, I recently got notification of this, a project next to my house here in town was done recently, and
This-
so.
that question
we
was
were
just
very
more for
well-
my
We were very well
personal-
informed and
I didn't know the
notified,
answer, and I just thought-
and the blasting itself, actually the whistle or whatever that goes off, the horn that goes off before the blasting
Yep.
was louder than the blasting. If that makes any sense.
Yeah, because it's
You didn't
all-
actually hear the blasting, you more heard the
Simple question, I
warning,
think
the
we
warning
can,
whistles.
I think we
Okay.
can maybe move on
All right.
from there. Okay, this doesn't actually pertain to a specific condition, it pertains a little bit to the overall project. I'd just like to know if the zoning board feels that they've evaluated the current town infrastructure in terms of people appointed to positions like the building inspector, in terms of, are we staffed adequately, properly to handle the magnitude of this project? And have we thought about a watchdog?
It's not our
It's
job.
not your job, okay.
Not our job.
And whose job would that be?
You have to talk to the selectman's office.
Okay, perfect.
One step that's happening, just so you know, which is going to help the building inspector, as of next week, I think it's next week, we have another secretary, which is going to, tomorrow, is going to work with Karen, which is also going to be working with the building inspector, which in this particular project will help out doing the permitting part of it, because there is going to be a lot of paperwork on that.
I think there's just a lot of everything with this
Right.
project. I think
But the
I'm
building inspector is working on stuff like that.
Okay. I think I'm done, thank you.
Okay, thank you.
Thanks.
Anyone else have any comments? Yes, sir.
Kevin Farrington, 58 Flag Road. About the no left turn restriction on Flag, the hourly restriction, I think we missed the point there a little bit. There's actually a morning rush hour and an evening rush hour. The traffic projections had the evening rush hour backing up from Route 9 even more than in the morning. So that left turn is going to become a cut through downtown to get around the mess that Route 9 is going to become with this project.
Well, I think the issue that I remember is school children and buses, and I think that was primarily the,
They get out in the afternoon, too.
no, I know that, but well, first of all, they may get out in the afternoon, but it's much more spread out. There's after-school activities. It's not in the same world as the morning where you have defined times when those buses are showing up and it's bunched up.
Directly coincides with rush hour.
Yeah.
morning rush hour.
I don't see that kind of impact, particularly, there's usually not a traffic backup on Flag Road because of the light at Crystal Pond going westbound, because it naturally stops the traffic. So there is a backup from Crystal Pond
It
east, for
hasn't
sure.
naturally stopped traffic since.
Excuse me?
Since the state has done their work with the third lane and everything, it hasn't really naturally stopped traffic.
Well, but there is a light there, and it does stop the traffic for a
Yeah,
couple
but
minutes.
the gaps, actually, I go out there every day, the gap's
Yeah.
closed. It's
I-
not, I wouldn't count on that. right?
Okay.
And the applicant's own traffic study says 466 feet in the afternoon rush hour. All of those cars coming out of the office building are gonna look for alternate routes. Flag Road is the only alternate route. You still have kids out there, you know. It's-
Well, I don't think that if someone wants to go westbound on Route 9, they're gonna wanna take a left out of Flag Road, onto Flag Road, and do a big circle around down Deerfoot and so forth. It doesn't, that is not gonna speed
No,
there.
it's actually gonna be Lovers to Lynbrook to 30.
Not, yeah, but if they wanna get on 495, they're not gonna go that route.
Now they're gonna go Lovers to Lynbrook to Northborough to Cimarron.
No, yeah, and that's gonna be quicker than waiting the
Way I do
three
it
car
every
lengths
day.
to get onto Route 9? I don't think so. I don't
I
think
do
people are
it
gonna
every
go down
day.
all those windy roads for that.
But again, yeah.
Yeah, okay. Anything else?
So I just
Yeah, what?
wanted to make the point that I really don't think this is gonna have the effect that you hope.
Okay.
And as you heard, the police department doesn't think it's enforceable anyway, so I appreciate the attempt, but I think it falls a little short.
All right, thank you for your input. Yes, Mr. Parry.
Yes, good evening. My name is David Parry, 22 Main Street, Southborough. I was on the planning board, and I was a Board of Selectmen member for many years. Excuse me. Oh, and the ZBA has a thankless job, frankly, here, and they do deserve, I guess, our thanks for persevering through this. On the other hand, I don't think it should be misunderstood that a huge number of people in this town care very deeply about this neighborhood. Just because they're not here doesn't mean they don't care. They're watching on television. I watched almost all of your meetings on television, and I'm sure many others are tonight, and they're very, very concerned about saving this Flag Road neighborhood, which has always been the issue essentially from day one, changing this zoning from what it was, light industrial, to the largest project in the town's history. And the impact the traffic will have on Flag Road, a scenic road with major trees and stone walls where traffic goes slowly. That's why people moved there. That's what gives the neighborhood value, and that's why people care, and that's why it's so darn difficult to come up with a mitigation issue, because people don't want to change the character. So I want to end my presentation to you with a question, and it comes from a meeting last night, which I watched on television, and town council was here, and many other people obviously were as well, regarding limitations to Flag Road. Now, the opinion, it seems to me, from you three, is it's perfectly adequate just to prevent a left turn with a sign on Flag at the end of this connector road, John Boland Road, saying no left between the hours of 7 and 9 a.m., except for school buses. But last night, we had a Board of Selectmen make a motion to prevent any left turns on Flag Road at any time. It was seconded, but that didn't go further than that because other members of the Board of Selectmen felt it wasn't the appropriate time because they hadn't yet had time.
Excuse me, sir, it was not seconded.
I don't.
Okay, no matter. It was proposed, maybe it wasn't seconded.
That's right.
It wasn't pursued.
Mr. Bartolini, it was absolutely seconded for discussion. The tape will show that.
Ms. Fanath, I heard her, I watched it, she
All right.
made the motion that was not seconded.
It's beside the point.
Please.
It's beside the point.
Okay. Go ahead, make your
The
point,
point is that a motion was made, and it was discussed, and it wasn't pursued because it was considered by the majority, in fact by all eventually, that it was the inappropriate time because the selectmen had not yet had time to have their own meeting on traffic. Because you always have said Flag Road is their problem. The selectmen will deal with that issue. And the selectmen haven't yet gotten to that issue because they just had a presentation a few weeks ago by the traffic consultant, and they haven't even as of today scheduled a meeting, have they? I don't think so.
Well,
but anyway,
we're here at the ZBA.
okay,
We're
so
trying
let me
to.
get to my-
I really don't want to discuss
Okay,
how
but
the
this is
selectmen.
the key issue. You tonight have are about to make a decision, I presume, to close the left between 7 and 9 a.m. Now, so I want to address this question to Town Council. It was inferred last night by you that the selectmen had the authority to prevent left turns, period, on Flag Road, because Flag Road was totally under their control. Is that the case or not? Does the Board of Selectmen have the authority to impose stricter conditions on exiting this site onto Flag Road?
But sir, excuse me, this is something that you could discuss outside of this hearing. This has nothing to do with the ZBA hearing tonight. What you're discussing about a selectman, I wasn't at last night's meeting. You weren't at last night's meeting. You clearly have information from watching the tape. I would suggest after the meeting, if you wanted to ask town council questions about the rights of the selectmen, feel free to do it. But right now, we're focusing on this hearing and our ability to make a decision.
Okay, well, my response to that is this is the key issue which people care about in this town. And it needs to be pursued, and it needs to be answered now. The selectmen need to know, and this neighborhood needs to know what authority.
There's been 2 traffic studies. You realize that, right?
Yes,
So
I understand
Okay,
all
so
of
you're
that.
not referring to either one of these traffic studies. You're saying it's the key issue to this project. We asked, the developer submitted a traffic, we had peer review submitted a traffic. Neither of them came up with any information that it would be a safety issue. We can only go by our professionals.
Sir,
So when people scream about traffic problems, we only could turn to the professionals. And I've asked on numerous occasions to people that make comments, if you could get an engineer to approve what you're saying, a licensed traffic consultant that will agree with what you're saying, I'll be more than happy to review it. But no one has presented any type of traffic study from the public that would debunk what we have so far from the 2 traffic studies that we have.
Okay, well, that is your opinion.
Well, no, this
But-
is
but-
fact.
but let
This
me-
is a fact. This is not an opinion. So this is fact. I've asked, if you've gone to the meetings, we've talked to the traffic study consultants on numerous occasions. The developer has offered to bring them back. We've brought our peer review back a couple weeks ago, and we've had numerous occasions to discuss it. We've had numerous occasions to offer, if the public wants to come up with their own traffic consultant that will debunk what we have, be more than happy to review it. It's the only thing we can go with. So we know it's a hot button issue. We feel as though that we've got all the information we need to get. Are you prepared to give us any new information so we can help?
No,
us
I
make-
want an answer from the town council, which I think is a very important question. And I think the town is owed it now, tonight. There's a Board of Selectmen member here tonight.
I
Why-
don't
why
think
can't
it's,
he
I don't
answer
think
this
it's,
question?
I don't think it's relevant to our
Okay.
discussion tonight.
So you want to avoid the question
I'm
being
not
asked.
avoiding the question. I don't think it's, Clearly, it was brought up at the selectmen's meeting. For whatever reason, the selectmen
Why
decided not
can't
to
the question
pursue it.
be
The
answered?
selectmen were aware of this traffic study for months. So for you to say that they just decided to look into it, they haven't had enough time to review it, is crazy. We've had the same traffic study that they've had for months. This is not something that was pulled out of a hat last week. So that's between you and the selectmen. We're
Mr.
here-
Chairman,
Yes.
I want to make a motion that there's no further discussion on the traffic study or Flag Road.
I'm very disappointed. I'm going to just say that for the record.
All right, thank you.
David? David, I want to add, Paul, I want to do that.
Manager Yazdani, 16A Bantry. A couple of issues, whether Mr. Bartolini feels we should stop talking about the traffic. Mr. DeGray, who is the peer consultant for the town, specifically said he feels dead-ending Flag Road will be the best move to make in terms of making Flag Road a safe road.
But that's not our decision, right? You understand that? That's not something that we could even...
I'm just correcting the
All
fact
right, but
that you were
let's
saying the
focus.
peer reviewer
This
did
is
not.
all, please.
All right, then let's
You've
bring
been
up
up here before. Let's talk about specific things that you want.
Be glad to.
Okay.
So bringing up issue that Mr. DePietri pointed to, published in Southborough Wicked Local, May 21st, 2014. Mr. DePietri Monday said he no longer plans to give the town nearly $500,000 in voluntary mitigation payment because of the way he believes he was treated. So going back to the comment that John Green made earlier, there was an offer out to pay $500,000 to the town for this development.
When and where?
May 21st, 2014, Southborough Wicked Local. I'll be glad to show it to you right here.
It's not,
It's not relevant because
it's not relevant.
That was prior to the thing, right?
There were certain discussions at one point that were taken off the table due to,
After,
We didn't even have our first hearing yet.
right? It was after we did that, right?
We didn't even have a first hearing,
Right.
because we filed and the town appealed it.
The point is that the offer was made, the discussion was had,
No,
that
there
he
was
was
not an
willing
offer.
to
the
put it
town,
down.
It was not an offer.
I don't think I was, the ZBA voted to appeal we appealed the permit process, the
Correct.
initial
The
permit.
town
Say that
did,
again now?
correct.
Right, we filed.
We
a-
didn't.
Right.
The Board of Selectmen's office and Planning Board did. We did not.
No, the zoning board
No,
voted
we,
to
the
deny
zoning
the
board,
project.
Denied the initial permit,
The initial permit application was denied by this board
and that's
as,
when the applicant at the time took the initial,
right, and we appealed it, you,
The initial
you
mitigation.
exercised,
Right, because of what the,
because we weren't, because it wasn't.
right, between the planning
So, I
board
mean,
and
that's-
town planner.
right.
So that was clearly stated that that was gonna occur, and it occurred, and so it's off the table now. So that was not the same.
Then why not put it back on the table?
It's not on the table.
It's not on the table.
Because the applicant is, said he took it off the table.
Well, why not approach the applicant and see if we can put it back on the
Would you like
table
to
and
put
make it a
that back
point
on
of
the table?
discussion?
No, it's not even up for discussion.
Yeah, because you don't want to pay $500,000 when the town is going to be incurring all sorts of costs.
Well, I think
All right, I'll move on. Thank
It
you.
was way early in the process, and things have changed. And
Considerably.
Yeah,
he's,
okay, well,
so
we're moving
it's
on to the
really,
next
it's really a
point.
moot point.
Absolutely.
Okay.
Moving on. Wanted to thank you, Mr. Eagle, for having a nice marathon session today to kind of test out our fortitude and stamina. I am curious to see, despite the fact that you had received numerous letters, including 2 from the Board of Selectmen members, to not have this meeting today. Why did we proceed to have this meeting this afternoon?
Well, originally, we were going to have a meeting on Monday and today. We had set that up last week, and when I got home from last week's meeting, I found out that I was going to be out of town. I had something that I had to do down in Connecticut, and I wasn't going to make it back for this meeting. So at that point, I decided to see if it was possible to basically combine both meetings.
Why not have a meeting next week when the people have an opportunity to review the drafts?
I feel as though that I owe it to the process. A lot of the stuff has been vetted. In fact, everything's been vetted as far as I'm concerned. And I think that we were, ready to start talking about the orders of conditions at that point. That's
All
why.
right. Do you feel like you owed it to the process because you're moving out of town?
I don't think it has anything to do with it.
I think it has everything to do with it.
Why? Has nothing, that has nothing to do
Well,
with it.
I think personally, it brings the question of this board into
I think that
knowing the fact that you have your house on the market, knowing the fact that you're going to be closing on your house any day, to take on the leadership role for this board, under the gun essentially, to wrap up this meeting and to finalize things. What are you pointing at, sir?
The permit expires on the 31st.
There's still some time next week.
No, the permit expires on the 31st.
There's still
and
some
we've
time
been
next week.
told- It's been stated, I think, this evening that it's
we've
not
had
going to be
numerous
extended.
meetings over the last month or two, numerous meetings, and it seems like every meeting we rehash the same thing over and over again. So at some point, we had to make a decision. We have to, we know that there's a possibility this could get appealed by whoever.
There's not a possibility.
Okay,
it will be.
we know, so let's move on. We're gonna try to cover as much bases as we can and let the chips fall where they fall. That's the only thing we could do. We owe it to the process. This developer was entitled due process. He was, you gotta keep in mind, this is a fellow that was entitled to a 180-day review. And granted, he has tweaked his proposal, and he's asked for extensions. We've granted extensions many, many times. But in the totality of this project review has gone on much too long, and we end up rehashing.
Much too long for who?
Much too long for the town. Okay, I know that we have a number of people here tonight, and I know that we've had discussions about how there's a strong connection for this Flag Road area, and the town is supporting it. But I've talked to people too. I live in town. People come up to me and say, listen, I support the project. I can't get to these meetings. I see it on TV. I'm not gonna show up and say I'm supporting, because I don't really want people to be looking at me funny. But I support
Did they write a
more
letter?
than one. Many people have
Did
come
they
up to me.
write a letter?
No, they feel as though they don't want to be part of the they don't want to be singled out. They don't want to be part of the process.
So these
This is something that they've
anonymous
talked to me.
friends.
I'm just telling you.
There's no reason to get into debate.
Right. Okay.
could I
Do you have
just-
anything else to talk about?
Do you have anything substantial to say?
Just on that point, there comes a time, similar to actions at town meeting, to call the question. And on 40Bs, once all of the concerns, and I'm not sure I've heard a new concern in the last 2 or 3 meetings I've been to call the question. Neighbors, there are rights to appeal. I think neighbors are aware of that if you have standing, and nobody wants that to happen. But at some point, you call the question. There's a regulatory time period that specifies hearings must be closed within 180 days of the opening of the initial hearing. We're at that point, and I think it's, as you say at town meeting, time to call the question. And I think that's what this board is going to do.
Well, is it time to question the fact that the current chair and the former chair make promises to the public in these hearings, and then they go back on these promises? Mr. Bartolini on multiple occasions said that commercial traffic is not going to go onto Flag Road. And yet we have the the occupants of the office park being directed down John Boland Road onto Flag Road.
Well, it's
Whether
not-
it's gonna
that's
be-
That was not my comment.
It's not commercial traffic, so office is not a commercial
Excuse me,
space.
sir, this is something that's been rehashed. You've brought this up many times. So if you could come up with some fresh
So what was your
comment,
comment, Mr.
that would be
Bartolini?
helpful.
Wait a minute. The reason the comment was made was when the traffic was going to go through Blackthorn and the other 3 roads up there, and the statement that I made was that the the building and the other places couldn't go through that road. They couldn't go up there. The new road that was built is on commercial property, and it's legally allowed to be done both ways. But the reason it was done originally, and originally said by me, was because abutters wanted to know about the other commercial traffic if it could go up there. And it wouldn't have been allowed to go up through those roads up there. On Bantry or what do you call? None of those roads could get commercial property. That was illegal. But the new road is not that, does not come under that.
Anything else, sir?
Would it be reasonable at this point to bring up conflict of interest?
You could make a comment.
Sure, I'll be glad to make a comment. Can you explain how your trailer with your signs is on a development that Mr. DePietri is working on right now?
Well, that was brought up by an attorney, and I explained to him after doing some research that that trailer in question was sold to another construction company years ago. They, for whatever reason, they kept our name on it, which happens in many cases when people buy our equipment, and they in turn apparently sold it or made I'm not sure exactly the relationship, but that trailer is on that property. It's got Bill DePietri's company name on there. There must have been some relationship between that company and this company. It had nothing to do with me. That happened many years ago, and I can't control what people do with equipment that they buy from me.
So the trailer's changed hands twice, and no one's bothered to take your signs off?
It happens all the time. I can't tell you how many people have seen our equipment in crazy places. I'm like, I sold that thing 15 years ago. It happens all the
Is there
time.
proof?
So, I mean, I can't control one
Is there proof?
Well, I mean,
That's,
Mr.
yes,
Cipriano?
Mr. Chairman, I have to take this, sorry. This is embarrassing. You, Mr. Chairman, are not on hearing. This project is on hearing. Continue on the conditions that need to be reviewed with the public at large.
Only.
Thank you.
That is the purpose of what we have just been doing for 6+ hours. Continue on with the residents who want to talk about the conditions, and if necessary, as Ms. Sussman did, suggest changes with others, and if necessary and appropriate, incorporate them. Respectfully, we all need to stay focused.
Thank you. Thank you. Sir?
Yan, Huang 75 Flag Road. I'm not sure this has any effects, but I want to start and just voice some brief grievances. It seems like the board at times treat this combined project 40A and 40B to either to treat it as 40B only or 40A only whenever it suits its need, and not address certain things when it says, oh, that's only 40A and that's only 40B, and it never gets combined and gets addressed. The problem, my issue with that is, in tonight, it seems that if the comprehensive permit is granted, then the use variance comes in effect, and then this whole project in effect is granted. My other issue with this is, there's mention of it that there's neighbors, abutters are in agreement, and I'm not one of those, and I would just like to state that fact. I'm not part of anything on any agreement with the applicant. So moving on to what's the focus of tonight. I was trying to look up some things regarding the enforcement on the private ways, and it so happens that apparently the police chief brought up that the enforcement is not possible, and this is a very murky area, so I would like the board to just defer to what the police chief said and actually consider something more enforceable than just a few signs, such as actually like the peer reviews suggested actually gating the connection from Park Central Drive to the John Boleyn, or what the Matt Stock suggested, no left turn. The other thing is on the uneconomic conditions, where that's what seems like the applicant has suggested. Mr. Marchand, I thought I asked you last time that the board can, in fact, actually request the applicant to show evidence by what you said of conducting a, what was it called it, a financial analysis, and then having them show actual evidence that such conditions or set of conditions would make it uneconomical. Given that the peer review and MassDAC suggestions, that seems pretty strong indication that at least evidence needs to be shown that, that maybe that condition is too harsh, but I would like to see or suggest that the board take such a move. What other thing? Other thing I want to bring up is about snow removal, in particular with regards to the need that the trees and grass clearing and stuff were suggested to maintain a required stop site distance at Flag and John Boland. With snow, I haven't gone through the snow removal plan, but is there a condition to make sure that snow doesn't, also during snowy conditions, that the stop site distance is met? Thank you.
Well, with regards to the snow plowing,
I mean, they're gonna plow
they're
it.
gonna plow in a reasonable
Push back the-
fashion. I
the
assume they're gonna
corners. Yeah.
give plenty of distance. Yep. Yes, sir.
Phil Jenks, the Planning Board. I've got about a half a dozen questions, and I think maybe one of them relates solely to the 40B. The others are broader project questions I'd like to ask to get some information that I think will help the Planning Board. Did I hear tonight a distinction made between the term connector road and spine road? That's all one thing, isn't it?
It's one and the same,
Thank-
and John Boland Road, all one and the same.
Right.
Okay, thank you.
We tried to consistently use the word connector road, but in previous drafts and discussions, it may have been called spine road, but it's one and the same thing. And it
I
just-
thought it was the other way around. I thought the connector road was the historical and spine is new, but that's fine, thank you.
It could have been, and then it got swiped, but that's why there's a certain inconsistency, but they're one and the same.
The plan, as I understand it, is to submit the overall project as, under the condo law to make it a condominium?
That is correct.
Are you talking one condominium?
You're talking about a four, as it's presently configured, a four-unit condominium with the right to subdivide existing units into more condominiums. The 40B complex will be one unit within the condominium, and then that will be an apartment complex, not condominium units. So there are 4 phases of the project.
But the owner is the same on all 4?
No, each unit, okay, will ultimately have a different or potentially different owner. As we sit here today, the owner is Park Central LLC.
If you divide the property into 4 pieces with 4 different owners, have you not made a subdivision?
No, because it's under the condominium law. Each unit will have its exclusive use area surrounding the particular building within that condominium unit. It's a process that we've used in other projects, and it's very common. So it's being developed as a condominium. It is not a subdivision, and there will be, ultimately, could be individual owners of different units.
Is there anything that shows the differences in the present plans and the concept plan that was done, Bill, was that a couple of years ago, or?
The concept plan that you're referring to was dated in April of 2014, I believe. The design of this, April 8th, 2015, the design that was submitted on the plan of records for this project and the plan of records that are before the Planning Board and before the Conservation Commission have attempted to substantially comply with this concept plan. The noticeable difference is the lesser density in the townhome component. Other than that, we are in substantial compliance with the concept plan.
Has that been determined by Mass Housing?
Yes,
Is that in writing?
yes.
Is a copy available?
It's been available, and it's been submitted with the board, and it's also an exhibit to this, but in a letter dated, and again, it's referenced in the decision, but subsequent to the initial site plan approval, we returned to Mass Housing, and I believe that the board's consultant may have even been with us at that meeting, okay, and Mass Housing approved the revision to the site eligibility, which relocated the 180 affordable units from one section of the site to the other side of the site. And that has been approved by Mass Housing.
Okay, is there a list, or is somebody putting together a list of the remaining, assuming this is voted in tonight, of the remaining items called for in the comprehensive permit?
I don't understand the question.
Yeah.
Additional approvals,
right.
You have obviously Concom, you have to get their approval,
Well,
and then you have the Mass Housing.
The
and you have
the decision references that this project is subject to the final order of conditions, the MEPA certificate, okay? The wastewater treatment license. So everything that is needed to construct the project is referenced in the decision.
So there's no master list that would make it easy?
No, but normally, after, or prior to the submission of the building permit, the town will review the comprehensive permit carefully and list all of the items that are required prior to the issuance of a building permit, prior to the issuance of an occupancy permit, and prior to the issuance of a certificate of occupancy.
Okay, when you say the town, is that the ZBA, or who does that?
It varies from town to town?
Do you know what our rules are?
No.
I don't either.
They might even hire a consultant to do it if they have the funds to pay the consultant.
Never know.
I'm tempted to ask Mr. DePietri if he wants to pay for another consultant, but I don't think I'm going to. Last question, I guess, is, assuming this is approved tonight, what can the developer do tomorrow that he couldn't do today?
Virtually nothing. We still are subject to conservation. We are subject to MEPA. I mean,
DEP.
and we still haven't, the DEP hasn't issued, I mean, there's really nothing much that we can do, that we couldn't do today, tomorrow. This,
It's a paper victory.
if,
So the rush to get this done today doesn't get you anything specific that you can do differently.
we don't consider it that it's been rushed at all, Mr. Jenks. If 30 months
I
is a
realize
rush,
that.
okay, then it's, but no, we cannot do anything tomorrow. We are, as you've heard from Conservation, we are at least weeks away from an order of conditions. You've heard from abutters that there's gonna be an appeal. There's nothing happening. It's finishing this aspect of the permitting so that we can move on to other aspects of the permitting and to deal with the issues as we come. So we can't do anything tomorrow that we couldn't have done today.
Okay, Mr. Marchant, if I may ask Mr. Marchant a question, is this a typical place in the process to be approving the comprehensive permit with as many open items as exist with this project?
I'm not sure. I should be answering that. I'm not sure I would agree that there are a number of open items. I think that the issues have been identified. The board has reviewed a list of conditions. Not everybody might agree with the conditions, but as I said before, at a certain point, you issue the decision. And my sense, and people have mentioned this, is that there could very likely be an appeal. And that's going to delay things, unfortunately. But I don't think this is unusual at all.
Okay, thank you.
We don't need to.
I think at this point, I'd like to make a motion, what?
There's one more item I thought of in the conditions.
Okay.
We need to have a specific reference to the architectural plans.
It's done.
Okay, could you just read it for the board?
Okay, I've plugged it in two places.
Make your motion.
Back, this is just by way of a little bit of history. Architectural plans were presented to the board probably 8 or 9 or 10 months ago. Those plans were dated August 14th, 2015, and we made a presentation. In condition 27 on page 7, I added the sentence to the end of that condition, which started the project as shown on a plan entitled, and then, which we discussed, and then I also added the following sentence: architectural plans dated August 14th, 2015 were submitted to the board and are attached hereto as Exhibit 8. So we have the architectural plans and we'll attach them as an exhibit. And then I also referenced the architectural plans. There was a second spot, I'm sure.
I would suggest you reference them on page 12, condition 2, where we reference the plans of record, and you reference the engineering plans and the architectural plans, and then you say collectively the plans of record.
Okay, well, then what we would do is we will move it from paragraph 22 on page 7. Follow what I'm saying, Katie? And move it to page 12.
Condition 2. And that references the engineering plans, and just through an oversight, the architectural plans didn't get cited. And then you'll say the architectural plans prepared by latest revision date, and then you say collectively, as a defined term, the plans of record. And then it will be consistent with the document.
Yeah, and we'll have to take a look at it, but Katie, I think you got that, Joe? Okay. And then we can delete, on page 20, Mr. Marchand, I also included as condition 28, the sentence, design of the project shall be substantially in conformance with the architectural plans attached as Exhibit 8, just to get that in there so that there was consistency throughout.
Thank you.
Yep.
Joe, are you understandable on all that?
Well, if I may, I'd like to make a motion to close the public hearing.
I'll second it.
Public comment.
Any discussion?
No more discussion.
I don't see any reason for any more discussions.
Okay. All in favor?
Aye.
Okay. So we've now closed the public hearing, and now we'll go into deliberations on any orders, any tweaking of.
Discussion of the decisions.
Right.
Joe, you've got them all written, right?
Yes, Katie and I have been going along trading back and forth, all the different discussions that have been going on and making revisions as the board and the applicant have suggested. So I think we've captured everything at this point.
We agree on what we've got done for decisions and discussion, right?
We've gone through one. Do you want to add anything more, Ed, or?
No, I don't think so. The procedural hearing, I think there's been a detailed discussion of the conditions. The findings are included in the decision.
Yeah, and as we've been progressing, your consultant in conjunction with our assistant has been making these changes. Maybe if the board wanted to, and you gave us a 5 or 10 minute recess, we actually can print out the changes that they have made to the documents as they were being voiced by the board. And you may have a product in front of you, but we certainly need a few minutes in order to assemble that.
I'll make a motion that we have it.
One question. There was a lot of, there's some special conditions that were stated, then we discussed and added more. Those are all numbered now? And they're numbered as, okay.
Yes, yeah. The only difficulty is a lot of them were integrated into the decision.
Right.
And that's why I would want to print it.
Okay, so why don't we,
Have Ed and the board look at it, and then you can, it'll
I'll make
take
a
a few
motion
minutes.
that we have a 10-minute or 15-minute recess, whichever amount of time it takes.
All right, I'll second that.
In favor?
Any discussion? All in favor?
Aye.
So we have a 15-minute recess till 10:35.
Thank you.
Did you do anything?
Not yet.
Okay, we're reconvening, we're reconvening the deliberative session, and we have a final copy that we'd like to distribute for review and signature.
Is that what this
Oh,
is?
yeah. I think you gotta move to either approve or I haven't heard a vote
Do we
yet.
want to review them first, or do we want to, I mean, do you want me to just make a motion?
Right, it's, Joe, if you could just state that it's, that you can attest that it's been the same copy as we had approved.
Yeah, I mean, the copy you have in front of you has been all the conditions that have been discussed tonight, with the edits as, as requested by the board and/or the applicant. So they've all been incorporated into the document you have before you right now.
Okay, thank you, Joe.
Thing is then that we take and,
Well, before we sign it, we have to vote to
So-
approve it, right?
then we make a motion of approval.
Okay, so I guess,
And put this with the motion of approval.
Right.
all right, I'll make a stab at this then. So I'll make a motion to grant the comprehensive permit with the findings and conditions discussed and agreed as stated in the draft decision and that we revised tonight, subject to final review by the town council.
I second it.
Okay, any discussion? Second, no, Lee. Any discussion? Okay, all in favor?
Aye. We have to sign this, right?
Yes, unless
We have to
it's,
sign
unless
it.
it's wet.
Right, the document did not get wet, all my notes got wet though.
Oh, I'm sorry.
We're signing
That's all
two,
right.
and I'm walking out with it.
Do we have to sign this?
Yeah, I won't get,
In blue ink, please.
whoa,
Blue ink, please.
blue ink, use this.
We have to just, how many we to sign, one or two?
Two copies.
Is this
That's the
one
same,
here?
that's the exact same thing.
Yeah.
What's that?
We're gonna need 3. I don't have access to the printer. It's not.
Well, we were gonna scan you one, but I can make, you can have three very easily.
Is that in the sheet that I'm supposed to-
You can just cross it off. You have,
We can print that last.
No, I have
The
enough.
town clerk is very picky.
Wait.
Yeah,
All right,
what's
so
wrong?
his name is spelled incorrectly.
Yeah, but hold on, we're not talking to them.
No, but we need
No,
to
we
re-
can correct the spelling of your name right now.
We need to correct his spelling.
Because you know, town
Sheets.
town clerk, yeah.
Paul, tell her how to spell your name.
It's D-R-E-P.
You need to do 3 copies of it,
Yep, he will.
She will.
because there will be an issue with town
An
clerk
hour ago.
if it's not properly done.
Okay.
That's better than crossing it out and just correcting it on
No,
the...
you cannot cross out.
clean names, clean drafts.
Yeah, you're here, you might as well.
I mean,
just
I
do it.
often misspell it myself, but it's tricky. That's the only word I know.
That's right, they just have to do the one sheet, right?
Yeah, that's it.
Yeah, no, it'll take 2 minutes.
Yeah, get rid of that, just that top sheet.
Oh, we're just gonna do that.
Yeah, this thing will stay the same. No, you can get rid of this. They're gonna
Do
just,
3.
yeah, I know, but they're gonna get rid of this
Yeah,
one's wrong,
she's
so,
making 3
yeah,
copies.
get rid of this.
Another set?
Because there's
We're
nowhere else.
getting one original.
No, but you have the third set?
Yes, right here. I'm waiting just for the signature page.
And that being said, I don't care if I name this spelled correctly, but I didn't want to...
This is the longest zoning board meeting we've ever had, I think.
11:20?
Oh, latest, we did actually, like...
Well, we started at
We did have
4:30.
one. We were here till midnight,
Yeah,
and we had to, like, evacuate the building before midnight.
right.
Because technically, does that, like, mean it, like, it's the next day or something? Or
Yeah.
It's like a different...
Hey.
Wasn't there
Yeah.
some...
Aaron gets it.
For the record, I'd like to state I did miss my 9:30 hockey game tonight.
Yep.
There might not be a next week. It was a
And I'll take
playoff
them
game.
home.
We need one. She needs 3, so
Yeah.
we need our own 2. We need
Aldo.
one. You need one in the
Okay, then we'll have 4.
Do you need them to sign this one?
I want them all signed. Where's the extra sheet? It's right here. No, but it goes with this. This goes here. Yep, so you're gonna sign 4. That's one with exhibits. Now you have 2 there.
Right, we just need the cut, we just
Flip
need
on
that
that
cut
one.
signed
Yeah, I
page
got it.
on the other 2. Okay.
Angel,
And that's the new, and that's the third one.
print out, he's emailing me one. Do you have any extra sets of the exhibits?
Yes.
Could I have
Yes.
the exhibits?
And this is the 4th one? Without the exhibits. I got the exhibits here.
Okay. Can you buy some extras?
I wanna make sure he gets this right set though.
Give us that one.
We'll sign them after you.
Oh, wait. that one.
I know, but I've been giving them out like crazy.
Here's the executed one.
Yeah, give to Aldo.
Got one here?
Yeah, I got this.
Okay.
Here's the second one that's executed.
You got one for Aldo, right?
I got one more if you guys want it, but I don't have the exhibits to put
Here's
with
the third one. Who's getting that?
I'll pick the boards.
Yeah.
And you want one more?
You have one for the clerk's office.
This is gonna be, this is the one that will go
That's
to
the one
clerk's
she's
office.
gonna
Do
bring.
you have another one for the board?
I have one here.
I'll get it back.
I mean, we don't necessarily need we don't need an original.
We got another one here.
Yeah, but we don't need an original for the, I mean, a copy is okay for us.
This is without the exhibits.
Well, no, by right should be filed.
Do they need a date in there?
With the clerk, but for our,
No, she got it on file.
Oh, there's that date.
Oh, it's right there.
On the bottom of the page, dated.
Who filled out the bottom part?
Oh, this
town
day,
clerk.
Oh,
this day, the 24th,
Okay, so there.
24th
you can
day.
write that in.
Can I just put it in?
One of
or-
them has to sign, have a 24.
Here,
Oh, yeah, no, we'll just go through, I'll just go through 24th.
Even that?
What? Is that all right?
Let me see the,
Yeah, where's the other one? Give me the,
He says that you can insert.
well, we,
yeah, well, we're still signing, so yeah. I mean,
That's the date of signature by the three members.
Right.
You can fill it in with ink.
right, that's what, but
So
you're,
now-
you're copied,
I'm giving you two. One has a different attached, one does not.
All right, why do I need two though?
yeah, we have to make a motion.
What I'm gonna do is actually, this one is gonna go to town clerk, it's gonna date stamp it in.
Go ahead.
And then I'm gonna get a whole, I'm gonna ask him for a whole copy.
Then here's an extra one.
Wonderful, all right, I'll take
Karen, are you all set?
it. If he doesn't want to give me an extra
I
copy.
think you're all set.
All right, this is just the decision itself. It's
All
not
right, just make sure she's all set first.
Aldo Fortsworth, do you need a 24 on top of yours, or
Karen, are you all set?
you're authorized to put that in there?
Karen, you're all set first.
He's gonna take that, scan it, okay?
Okay. make a
Mr.
motion.
Chairman, I make a motion that we close our public meeting.
Second?
Yeah, sure, I'll second that. Or do we have any other items?
Just adjourned, I think.
No, do we have any, well, there's nothing else that
No.
we need to?
All right.
Then I second
Okay.
that, and
All right, any discussion?
No
All in
discussion.
favor?
Aye.
Okay, thank you.
thank you.
Thank you, guys.
Got it.